Good morning, everybody. Happy Super Friday. Welcome to TCF Live, where for the second day in a row I have forgotten to update the intro, but life will go on. Let's start with Magistrate Bankey.
City of Royal Oak versus Dillon James Shield. Your appearances, please.
Ready, Honor. Michael L. Steinberg, P43481, on behalf of Mr. Dillon Shield. The Honor, he has been, before we start, his address has been verified.
On Gas Glow.
Yes, ma'am. Sterling
Okay,
Heights.
thank you.
And his Dillon is spelled, I believe, Dillonion.
Correct.
So I just want to make sure I have that right. And
Okay,
Dillon's
so one
phone,
second. Our official record or ROA says Dillon, but you're saying your name is
no, Dillon's, give us
Dill.
a correct spelling of your name.
It's Dillon.
Oh, there you go, Your Honor.
Okay,
Forgive me, Your Honor. Okay,
so we
Dillon's
have it
name,
correct, and then I did it on the screen wrong. My
yeah,
bad. My
that's what threw
apologies.
me off,
There
Your
you go.
Honor. Okay, Dillon's phone number is 248-596-2986.
Okay.
It's 248-996-2986.
We're batting 1,000. We got the name wrong. We got the phone number wrong.
Boy,
248-996-29.
email Dillon, the way he spells his name, @gmail.com.
Thank you.
Okay, so that corrects all that. As far as the information, for the record, Michael L. Steinberg, P43481, on behalf of the defendant, I've advised him of the nature of the offense to his satisfaction, waived the reading therein, asked this court to enter a plea of not guilty. In addition, he's been advised of his constitutional rights as they have attached today, including counsel. He understands that, waiving the reading of those, consent to being on Zoom.
Okay. The court will waive the formal reading based upon your representations. Thank you for saying. I've confirmed the address and the phone number for this litigant. He pleads not guilty, and not guilty plea shall enter. Is assigned counsel requested?
Yes, ma'am.
Okay, that's granted. Counsel shall be assigned for this gentleman. And is he an Operation Drive candidate?
Yes, ma'am.
Thank you. And what do you have to say about bond and bond conditions, please?
His license is truly reinstatable. It needs some assistance through Drive. He actually was here at the appointed time today. I apologize. I had it at 8:35 for some reason on my end. And
You're forgiven.
okay, so he is here and will be in Drive, so there's no reason not to give him a personal bond at this point.
Okay. The bond is $3,000 personal bond. No monies due at this time with the following conditions, sir. You must personally appear for any and all court events that have this case name and case number, no matter how they're titled. If you go in Operation Drive, there's a lot of review hearings. It's the order of the court and a condition of this bond that you see that program to the conclusion, and you appear for any such hearing. If you fail to do so, then that will be a violation of the conditions of your pretrial release. You shall abide by any judgment in this case, surrender to serve any sentence imposed. Do not commit any crime while released. Do not drive without a valid license or permit. You shall immediately notify the court in writing of any change of address from Gasglow in Sterling Heights or the phone number ending in 2986. We're going to set this matter for a pretrial. You will have assigned counsel. That'll be Mr. Steinberg, right?
Yes, ma'am.
The notice to appear will be mailed to you to Sterling Heights address. And when you get that notice, you have Judge K right now, as it stands today. Judge K is doing his pre-trials by Zoom. So you're going to get a notice to appear from here on out. Hopefully you and I don't meet again. And you're going to be before the trial judge. It'll have a different Zoom ID than you use today to log in. So make sure you look at your notice and log on to the proper courtroom. To recap, we held the arraignment, confirmed the address, the phone. I received an email address, waived the formal reading, not guilty plea, assigned counsel, operation drive, 3,000 personal bond, standard court rule conditions, although he may trial, he may not drive without a valid license or permit. We'll set this matter for a pretrial. He will have assigned counsel. The notice to appear will be sent to Sterling Heights. Yes, sir. You have to unmute yourself.
So what is the $3,000 bond?
It's a personal bond. You don't have to post any money at this time. If you fail to follow the conditions of the bond, that number may come into play later.
Oh, okay. Thank you.
But no money is due at this time.
Okay, thank you.
So personal bond. Mr. Steinberg, anything further requested or required of the court on behalf of this gentleman, please?
No, ma'am.
All right, thank you, sir. This concludes your arraignment. You are free to leave the Zoom or you may stay and observe, your choice.
Thank you.
Mr. Stein.
Good morning once again, everybody. TCF Live on a Super Friday. Jonathan celebrating 3 months with us. Thank you for being here with us. We've enjoyed having you. And Barbara, $10 cat treat fund for our co-host Ellie. Thank you, Barbara. Great way to start off a Super Friday. Really appreciate that. Let's get back to the magistrate.
Are the informals. I call those now.
Magistrate, I do have
Yes, sir.
others, 9:33 or 31 and 9:46. So I'll just.
No, I know. They're just not here yet.
Okay,
right?
fair enough.
Are they here?
No, ma'am. I'm just.
Well, wait, I have some people. That's no, that's informal.
While we're waiting for Magistrate Bankey to get set up, notice to all of you, during the third hour today, I will have an announcement about TCF and something new that will be happening. So be sure to stick around for hour 3 so you can be up to speed on that. I think you guys will like it. It'll be fun.
I'm going to call my 8:31 informal docket now, starting with Mr. Strasser, calling the cases. Are you ready, ma'am? 26RO04164, 26RO04164A. This is the City of Royal Oak versus Joshua Merrick Strouster. Your appearance, please. That means tell me your name, sir.
My name is Joshua Strouster.
Okay. What time is that? 8:54. This was the date and time set for your informal hearing. It was set for 8:54. And the officer has failed to appear. The court has given him or her the courtesy of 15 minutes to appear. He's failed to do so. So both tickets, 164 and 164A, are dismissed without prejudice. Any objection?
No objection.
Okay, thank you so much. That concludes your hearing, sir. You may leave the Zoom.
Have a
Take
good
care.
day.
Be well. Have a nice
Bye.
week.
You too. Thank you.
Calling the case of 26RO03720. This is the City of Royal Oak versus Rossan Jamal Lewis. Your appearance.
Rossan.
Oh,
It's
Rossan.
Rossan Jamal Lewis. Yep. Good morning,
Rossan, right. Just
Mhm.
just as it's spelled. I'm so sorry.
No worries.
Rossan Lewis. Okay, state your name again, please.
Rossan Jamal Lewis.
Okay, good morning, sir. This is the date set for your informal hearing. This was set for 8:31. It's now 8:55. The defendant has appeared. The officer has failed to appear. Therefore, this ticket is dismissed without prejudice. Any objection?
I only have one question, Your Honor. I already paid the fee for the
Right, I'm
ticket.
going to order that the bond be refunded.
Okay. Thank you, Your Honor.
Okay?
Mhm.
I don't know, Madam Clerk, do you know how we refund bonds? Can they come to the counter or is it mailed? I'm not sure.
Or does it go back on the card that I paid it?
Calls and wants traffic.
Could you call the traffic and ask them how the bond is refunded? I'm not sure. how it
No.
is.
They told me, so I called them. They told me what I needed to pay. And then they said for this court date that if, depending on how everything went, that it could be refunded, but they never went into the details about
Okay,
how.
that's what I'm saying. Call the traffic. When you call, hit the prompt for traffic and ask to speak to a traffic clerk. Because they
Okay.
would know the administrative end of it. I've never processed a refund, so I can't help you.
Okay. Thank you.
Okay, thank you. Sorry, I could not be of more help.
No worries. Have a good
Okay,
one.
take care. Be well and have a nice weekend.
Thank you.
Okay. Eileen.
It's Ross. If it is, I'll remove.
Okay, Eileen, are you Eileen Ross?
Yes.
Okay, thank you. Do you have it? Are you doing?
Yes, I would.
Okay. And Mr. Steinberg, I was going to say, you don't have anyone in the waiting room or breakout room, do you?
Not that I know of, no.
Okay. The other magistrate was here this week and everything's like a different setup on the Zoom, so I'm not oriented yet.
I was there with him yesterday.
2 days in a row you were here.
Yeah, I know. I hit the
Wow.
jackpot.
Is that sarcasm or?
No,
you like it
ma'am,
here? That's
after
nice
the
to
week
hear.
I've had, I do not mind having this kind of
That's
docket.
so nice. That's so nice. Okay. So we have Irene is number 2. And so who's this person that just came on?
Good morning. I have 9:01, so I might be a couple minutes early. I'm sorry.
Okay.
Let me
That's okay.
change the
One
name
second.
on there.
We'll change that for you. Are you?
Michelle Ludastansky.
Okay. You'll be the third one to be called.
Okay.
So
thank you.
for the 901, you might not be. We're waiting for officers. Is it troopers or officers? These state tickets. We're looking for troopers or sergeants. Morris for you, ma'am, and Smith for the other 2. So whoever officer gets here first, I'll call his or her tickets first. Okay?
Well, we'll let the magistrate get things sorted out, but let's stay in the same court, the 44th, but let's go say good morning to Judge Meineke.
The court had moved this case just a couple weeks because I needed to find out. Mr. Slappy had, of course, as we've discussed, had a significant criminal history and was on was on parole, and the court wanted to find out what his status is on parole. And my probation staff reached out to Chandra Price, who was his parole agent out of the Detroit Metro District Parole Office. And the response was that he has been on parole since 2021. his adjustment is very poor. The subject is a chronic absconder who fails to report as instructed, abide by his parole conditions, and sanctioned parole board tether curfew. He has a history of changing his address without permission of his agent. The court is also aware that since he was placed on parole in 2021, we have had multiple contacts, 2023 out of the 46th District Court for disturbing the peace, 2023 out of Ferndale for retail fraud second, 2023 out of 6th Circuit for possession of controlled substance less than 25, 22 local ordinance retail frauds that have already been dealt with, and then we have the pending matter here before this court. So obviously there are some challenges here, and the court needed to have this information before it would proceed to sentencing. So I didn't know if Ms. Nuccio, if you wanted to weigh in at all on sentencing. I certainly would give you that opportunity. Then I would want to hear from Mr. Falick and Mr. Slappy.
Thank you, Your Honor, for that opportunity. I actually recognized the defendant's name from prior cases of my own, which is never a good sign and is indicative of the criminal history Your Honor spoke of. I don't think this is a candidate for probation and would ask for he to have the maximum incarceration sentenced. We do seek restitution in the amount of $261.42. The merchandise was not recovered here.
All right, thank you, counsel. Mr. Falick.
Thank you.
Mr. Falick, you're frozen. Mr. Falick?
Judge?
I can hear you now, Mr. Falick. I can hear you now.
Thank you. Thank you. Sorry for the bandwidth issue. Right. I can only indicate to the court that, I've had discussions with Mr. Slappy, and he is, understands the gravity of the situation and what it means to be a repeat offender. He's still, motivated to pay his debt to society and to get clean and stay clean. Again, that's something I would like to have seen, at a previous trial, but here we are, and he can also speak for himself if he wants to, but my impression is that he's motivated to work however he needs to get beyond this.
Okay, Mr. Slappy, is there anything you'd like to say before this court imposes sentence?
Yeah, I just apologize to the city, Royal Oak, and I accept full responsibility for my actions, and I'm just look forward to get all these warrants cleared up and start my life like I'm supposed to.
It seems to be a significant drug issue, controlled substance issue that is motivating this behavior. Would you agree with me, sir?
Yes, sir.
Yeah, so Ms. Nuccio, the court's plan was to order restitution. He had some prior retail frauds that I think the city had dismissed with the understanding that he was going to, we were going to incorporate restitution for those files on this one. And so his restitution order is actually going to be $389.96, $261 plus $128.96 for the other files that were incorporated sort of in this global resolution. Mr. Slappy, I have no really basis to give you any type of reduction in sentence. There's just a significant history of criminal behavior. Your parole agent, who's known you, that the parole record is poor and can't be ignored. So it's the sense of this court. I will give you one small opportunity. It'll be up to you whether you take it. It's a sentence of this court that you'll serve 1 year in the Oakland County Jail with 45 days credit. And it will be suspended after 9 months for ATI treatment. So basically what will happen is around the 9-month mark, they'll come and say, hey, do you want to do the rest of your time in custody or do you want to do the rest of your time in a treatment program? I hope you choose the treatment program. It will be a slight reduction in time. It'll be 28 days rather than the remaining 90 days. Madam Prosecutor, I do think that at least puts us in the best possible position for success long term. We have a large chunk of incarceration and then a gradual reintroduction with treatment before he gets put back into the general population. I'll waive any fines and costs outside of the restitution. And good luck, Mr. Slappy.
Excuse me, Your Honor. Excuse me,
Yes.
Your Honor. Can I be eligible to take this class in here, CBP?
Well, they'll send me requests for time cut. Right now, I'm not. I've given you the grace of a treatment program at the end. I'm not really at this point in time looking for further time cuts. But the Oakland County Jail will send those type of requests to me for review, and I'll see how you're doing. On your own while you're in jail. I know that there's meetings there. I know that there's opportunities for you to work on your sobriety. Certainly, if I hear about that, maybe I'll look at some sort of additional time cut to get you into the treatment program sooner. But for today, from what I know, this is an appropriate sentence. Good luck, sir.
Thank you.
Alrighty, friends, let's change it up a little bit. Let's go down to Lubbock, Texas. They're currently holding their magistrate court. Let's check in on that.
Jeff Nicholson, and your bond to be $100,000. Do you have any questions? You want a copy? Thank you, sir.
Have a great day.
Thank you. You too. Johnny Reyes. Sir, we have your name spelled Johnnny, and then your last name Reyes, and then hyphen PINON. Your date of birth be June 12th of 1992. You have been indicted for controlled substance penalty group 1 or 1B between 4 and 200 grams. It is a second-degree felony. The indictment reads that on or about May 24th of 2024, you intentionally knowingly possessed a controlled substance, namely methamphetamine, an amount of 4 grams or more, but less than 200. I am entering a plea of not guilty for you. I show your attorney to be Isaiah Solarizano and your bond to be $20,001. Do you have any questions? You want a copy? There you are. Thank you, sir. Thank you. Destiny Rodriguez. Miss Rodriguez, we have your name spelled D-S-T-I-N-Y and then your last name R-O-D-R-I-G-U-E-Z. Your date of birth May 10th of 2007. You have been indicted for aggravated assault with a deadly weapon and 2 counts of that. They're second-degree felonies. The indictment reads that on or about June 7th of 2026, you intentionally knowingly threatened Mariah Mendoza with imminent bodily injury by pointing a firearm at her, and you used or exhibited a deadly weapon, namely a firearm, during the commission of the assault. Count 2 is that on the same date, you intentionally knowingly threatened Marissa De La Fuente with imminent bodily injury by pointing a firearm at her, and used or exhibited a deadly weapon, namely a firearm, during the commission of the assault. I am entering a plea of not guilty for you. I show your attorney to be Philip Johnson and your bond to be $100,000. You want a copy? Yes. Do you have any questions? All right, thanks. Rocky Rodriguez. Mr. Rodriguez, we have your name spelled R-O-C-K-Y and then your last name R-O-D-R-I-G-U-E-Z and your date of birth to be August 31st of 1981. You have been indicted for aggravated assault with a deadly weapon. It is a second-degree felony. The indictment reads that on or about May 16th of 2026, you intentionally, knowingly, and recklessly caused bodily injury to Jose Lopez by striking his face, and you used or exhibited a deadly weapon, namely a knife, during the commission of the assault. I am entering a plea of not guilty for you. I show your attorney to be Chris Warner and your bond to be $50,000. You have any questions? You want a copy? Guadalupe Salinas? You're welcome. Mr. Salinas, we have your name spelled Guadalupe, and then your last name Salinas. And we also have you listed as a junior, is that right? You have, excuse me, in your date of birth, April 11th, 1989. You have been indicted for possession of a controlled substance, penalty group 1 or 1B, between 1 and 4 grams. The indictment reads, and it's a 3rd-degree felony. The indictment reads that on or about August 5th of 2025, you intentionally knowingly possessed a controlled substance, namely methamphetamine, in an amount of 1 gram or more, but less than 4. They are alleging you have a previous felony conviction on April 20th of 2021 in Lubbock County for possession of a controlled substance. I am entering a plea of not guilty for you. I show your attorney to be Ashley Sanders and your bond to be $10,000. You have any questions? You have a copy? There you are. You're welcome. Francisco Sanchez? Mr. Sanchez, we have your name spelled Francisco, and then your last name Sanche. And your date of birth to be March 13th of 1990. You have been indicted for attempt to commit robbery, a 3rd-degree felony. The indictment reads that on or about May 25th of 2026, with the specific intent to commit the offense of robbery of Angel Brown and Brahms Ice Cream and Dairy Store, do an act, namely by presenting to Angel Brown a note intended to place Angel Brown in fear of imminent serious bodily injury if she did not surrender money to yourself, which amounted to more than mere preparation that tended but failed to effect the commission of the offense intended. There is an enhancement paragraph stating you had a previous felony conviction on February 8th of 2018 in El Paso County for robbery. I am entering a plea of not guilty for you. I show your bond to be $5,000 and your attorney to be Timothy Williams. You have any questions? You want a copy? Mizarius Williams. See, I got it right today. I was practicing yesterday. All right, sir, we have your name spelled Mizarius, and then your last name Williams, and your date of birth 6th of 2001. You have been indicted for unlawful possession of a firearm by a felon. It is a 3rd-degree felony. The indictment reads that on or about December 31st of 2025, having been convicted of the felony offense of tampering with physical evidence on July 3rd of 2024 in Lubbock County, intentionally knowingly possessed a firearm before the 5th anniversary of your release from confinement following conviction of the felony. There is a previous felony conviction they are alleging on September 28th of 2021 in Lubbock County for evading arrest or detention with a vehicle. I am entering that plea of not guilty for you. I don't show you have an attorney yet, but that your bond's $50,000. Did you talk to someone yesterday about getting an attorney? Huh? Oh, you have one? Who is it?
Kayla.
Oh, Kayla Staley? Okay. She was appointed, right? We just haven't got her added to this case, so we'll get her added. Any questions? You want a copy? Thank you, sir. And then we'll just do the Patiamo like after our 10 o'clock. Okay.
Well, I guess we're going to mute down in Lubbock, Texas. That's fine. Let's go to Florida. Wade Mercer.
Take somebody out of order. The first case is Hayden Johnson. Mr. Johnson, good morning. Mr. Johnson, you're here because Mr. McDaniel's been working or somebody at the jail's been working on trying to find you a placement. So listen to your attorney, Mr. McDaniel. We're going to see where we stand, sir.
Your Honor, at this point in time, I talked to Mr. Johnson. Ashley and Stephanie from the Sheriff's Office are going to be transporting him with the court's approval to the Haven House in Santa Rosa County. And that's where he's going to be at. We just asked the court to consider going and give that conditional release to go there, put it on the September 16th court docket. He doesn't have to appear as long as he's there still in the Haven House. But if he happens to not be there and he's not in jail, he needs to be here on September 16th.
Thank you. Mr. Gill, is that agreeable with the state?
It is, Your Honor.
Thank you. Mr. McDaniel, is the plan for transporting him today or the first of the week?
Ashley told me yesterday that they could, I want to say they said that they could transport him today, but I'm just going to ask at their earliest convenience, and we'll let them know. And, whether it's today or early next week, I'm not sure, but I thought they said they have time today. But
You need to bring him up. We're going to put him.
Is there a condition that he has to successfully complete the
I
program?
think that's what we did last time.
Okay.
Last time there were some medication issues at the other program. So I think what we did is we gave him a conditional release, just a regular conditional release with a condition that he enter and successfully complete the inpatient drug treatment program. Mr. Johnson, just like last time, Mr. Mitchell's already told you, as long as you do that, then he's going to evaluate the case, which I think involves a family member. And if you do that, then he may dismiss the charges. He told you he would look at it. But as long as you complete the program. On the other hand, if you leave the program or don't complete it, then that's a violation of your conditional release. Mr. Johnson, any questions about that?
No, sir.
And you do want to go to the program, correct?
Yes, sir. Very much so.
Mr. Goodson?
So the name of the facility again, John?
Haven House.
No, we don't know when he's going.
Hopefully today.
Today or early next week. I suspect today, but I want to say, I know they told me they.
We'll know by the time Joe gets him here.
Okay, so that's in Santa Rosa?
Judge, if you have that letter I sent you.
I got it. Mr. McDaniel sent an email yesterday. I'll open it up. Give me just a second here and we'll.
Oh, I got it. Okay, thank you.
Were you on that email? Yeah.
Okay, thank you.
All right, so we'll see you in a little while. Wish you the best, Mr. Johnson.
Yes, sir. Thank you very much.
Yes, sir. Antonio Franklin's next. Mr. Franklin, good morning. Mr. Franklin, you're here because you've been accused of 3 new charges, sir. You've been accused of 1 count of scheme to defraud less than $20,000. Count 2, grand theft between $10,000 and $20,000. Count 3, uttering a forced instrument. These are all 3 third-degree felonies according to the warrant. So, Mr. Franklin, there is probable cause. I think I may be the judge. I am the judge that signed the warrant. So I found probable cause before I signed the warrant. I've also looked at your criminal history, which according to the Department of Corrections website, you've been to prison twice, got out most recently in March of 25. So that's what I have. I'm going to listen to the attorneys and I'm going to set your bond if you're entitled to one. I think you are at this point. Mr. McDaniel, anything on behalf of Mr. Franklin?
No, Your Honor.
Mr. Gill.
Your Honor, I believe he's entitled to a bond based on his prior prison sentences. And when he was released, it looks like he would be qualifying for HFO. And based on that, we're asking for a high bond.
Thank you. Mr. Franklin, HFO stands for habitual felony offender. It's a charging decision the state can do if someone qualifies. It increases the potential penalty and actually makes a minimum mandatory if you're convicted, which you haven't been convicted of these charges, you've just been accused. But if you're convicted and if the state files a habitual felony notice, then that can cause certain minimum mandatory to apply. It actually makes the statutory maximum become the minimum mandatory, I think.
Well, I believe HFO would increase the ceiling to 10 years for each count.
Okay, it doubles it.
I don't think there's any min-man.
Then there's a habitual violent felony offender, which makes it a min-man, right?
That might be true.
Prison release reoffender. There's 3 different ones.
HFO,
Okay.
something like that.
So, Mr. Franklin, I'm going to set your bond at $7,500 on each of these third-degree felonies. That's based upon your criminal history, as well as the amount of money you've allegedly illegally obtained. So that makes a total bond of $22,500. You have a condition to have no contact with any branch of People's South Bank. That's the alleged victim. Mr. Franklin, you're going to get a chance to use the phone, sir, to try to post the bond. In just a few minutes, you'll use the phone. The jail also is going to give you a notice for your court date. Your court date will be September 1st at 8:30. So they'll give you that written notice in just a few minutes. If you post bond, you'll have to be there September 1st. If you don't post bond, the jail will get you to court on that day. Mr. Franklin, do you have any questions?
No.
Wish you the best, sir. Mr.
Yes, ma'am. I'm sorry. Mr. McDaniel, on Mr. Johnson, I apologize. So when he was originally placed on conditional release, there was a condition to have no contact with the alleged victim in a battered domestic violence case. I assume that's still in place? Or
yes.
No?
Yeah, I think
Okay.
it's his aunt. I mean, I've talked to them all. They're not even gonna, so I don't know if they want no contact, but yeah.
She hasn't. Go ahead, Mr. McDaniel. I didn't mean to interrupt.
Yeah, I don't know if they actually want no contact, but I don't see no issue with it. It's with his aunt, so.
Okay, I just wanted
Yeah,
to clarify.
for now, that'd be in place. Now, if she wants contact, which she hasn't requested as far as I know, if she wants it, we'll cross that bridge, but until then, no
Stephanie said that
contact.
transportation is probably gonna happen Monday.
Okay.
Thank you. After Mr. Franklin, we have Larry Long. It's called Haven House. Mr. Long, good morning. Mr. Long, you're here because you've been accused of one count of possession of drug paraphernalia. Mr. Long, I read the complaint. There is probable cause in the complaint. I've also looked at your criminal history. I'm appointing the public defender's office to represent you for first appearance purposes. Please listen to your attorney, Mr. McDaniel.
Your Honor, I've talked to Mr. Long at this point in time. We're going to plead no contest to the charge of paraphernalia. Understanding he's going to be sentenced to 30 days in the county jail, 1 day jail credit, $385 fine. He has signed his plea waiver form, waiving his right to jury trial and call witnesses.
Mr. Gill, is that agreeable with the state?
It is, Your Honor.
And Mr. Long, do you have any questions about that agreement?
No, sir.
Mr. Long, is that the plea you would like to enter to resolve this case?
Yes, sir.
This is a case where he was offered a choice between probation or a short jail sentence. And Mr. Long, you just want to get it over with. Is that right, sir?
Yes, sir.
All right. I'm going to accept your plea of no contest to the charge of drug paraphernalia possession. Judge, you're guilty. Sentence you to 30 days in jail, 1 day credit, no probation, Mr. Long. In this case, sir, I'm going to impose the court costs and fines that I have to under Florida law, which is $385. In this case, Mr. Long, you've got 1 day credit. Hopefully you're going to get you some extra game time, sir, and get out of there a little early, be through with this and put it all behind you. Mr. Long, do you have any questions?
No, sir.
Wish you the best, Mr. Long.
Yeah, thank you, sir.
Yes, sir. Henry Lee Ward, Jr. Mr. Ward, good morning. Mr. Ward, you're here for first appearance accused of 1 count of battery, domestic violence, and 1 count of felon in possession of firearm. That's a misdemeanor and a second-degree felony. Mr. Ward, there is probable cause in the complaint. When I looked at your criminal history, it's very lengthy, and it includes a prior domestic violence charge against the same alleged victim last year. That case was dismissed, though. So, Mr. Ward, I think you're entitled to a bond as far as I can tell. I'm going to listen to the attorneys and I'm going to set your bond. Mr. Gill, there is an error in the complaint that y'all may need to know about, because I was trying to figure out how it says 2213 Delwood Cypress Road, and then it said it ran to her neighbor's residence at 6180 Delwood Cypress Road. So my question was, how can 2213 be a neighbor of 6180? But when you look when you look at the front page of the complaint, it says 6180 Highway 90. So in one place in the body, it says 6180 Delwood Cypress. On the front page, it says 6180 Highway 90. So I think that
Thank you, Your Honor. I'll
that's
make
a
note of that.
mistake. So when y'all mail or anything or contact her, y'all need to be aware of that.
Yes, Your Honor.
So, Mr. Ward, I'm going to listen to the attorneys and I'm going to set your bond if there's anything if you're entitled to one. Mr. McDaniel, anything else?
Nothing, Your Honor.
Mr. Gill?
Judge, we're just asking for a reasonable bond that he have no contact with the alleged victim.
Thank you. So, Mr. Ward, your bond's going to be $5,000 on the battery, $25,000 on the second-degree felony and felon in possession of firearm. No contact with the alleged victim. Mr. Ward, your total bond is $30,000 cash or surety. Surety means you can go through a bondsman, sir. And Mr. Ward, you'll get to use the phone in just a few minutes. Just have no contact with the alleged victim at all. And the jail staff will give you a notice for your court date, which should be September 1st at 8:30. Mr. Ward, do you have any questions?
Yes, sir, I do.
Okay.
I have a daughter that goes back and forth to Birmingham Children's Hospital, and her procedure is September 1st, sir.
Okay. Tell me about the procedure she's having.
She has neurological problems. She has a misfire on the left side of her brain. It deals with her brain waves. So they'll be hooking her up for her overnight study procedure and try to monitor those waves and try to get them accurate. She just started her liquid Keppra, and we just started her on 2 rescue nasal medicines as well, sir.
So is it a surgery she's having, or is it just an overnight observation?
Overnight observation. Should just be hooked up, monitored, so they can do the camera test to try to monitor those waves, and that's September 1st as well, sir. And I'm the only one that drive.
How old is she?
3. She's 3, sir.
Do you think you're going to be able to post the bond I've set, Mr. Ward?
I'm going to do my best, sir. Yes, sir, because I need to be out.
So,
I do need to be out.
Mr. Gill, what I may want to do is we may want to set him for the October arraignment date if the state's not opposed to that.
I have no objection to that, Your Honor.
Mr. McDaniel, what do you think?
No problem with that, Your Honor.
Okay, so we're going to ask the jail not to put you on September 1st. We're going to ask the jail to put you on. Well, here's the problem with me doing that. The problem with me doing that is if you're still in jail, you still wouldn't be able to come to court until October.
Right.
So
I plan on trying to go ahead and come out, sir. That's
okay,
that's my ultimate goal.
Let me do this.
Ready to be back at work by Monday.
All right. So here's what we'll do then. So if he's still there 1 week from today, Sarge, put him back on the first appearance list.
Okay.
Okay. So I'm going to ask that y'all give him a notice for October. And the October date is October 6th at 8:30. But Mr. Ward, if you don't post bond, I don't want you sitting there until October 6th. I want you to come to court on the September date. So if you're still there a week from today, if you haven't posted bond, you'll come back to first appearance, and I'll probably change that back to September 1st. If you do post bond, you've got the October 6th date. Any questions?
No, sir.
All right, sir. Have a good day. Mr. Ward, come back up. Let me ask you a question. Is the mother of this child the same person as the alleged victim in this case? Is that the same person?
Yes, sir.
All right, Mr. Gill, so my concern would be them both being at the hospital, which they probably both need to be for a child that age. What's your thoughts about that?
Judge, given the narrative, and we're asking for no contact based on what is alleged in the complaint.
Yeah, so the way we would do that is, I've been to UAB recently. They have a really big waiting rooms. So you both could be at the hospital. You can both be at the hospital. You just can have no contact with you. You cannot talk to her. Okay?
That's fine, sir.
All right. Have a good day. We have Taki and Poole. Mr. Poole, good morning. Mr. Poole, you're here for one charge, new criminal charge of giving false name to law enforcement officer. You also have a couple of child support issues you're going to be seeing a hearing officer on the not giving the false name to law enforcement officer. There is probable cause. I'm going to appoint the public defender's officer to represent you. I'm going to ask that you listen to Mr. McDaniel. We'll see where we go in that case.
Your Honor, we just asked for reasonable bond.
Nothing from the state, Your Honor.
Okay, Mr. Poole, thank you both. Mr. Poole, I'm going to set your bond. Let me look at your criminal history again. There was a prior resisting in the last couple of years, but it wasn't the same type of resisting. It wasn't to do with giving a false name. It was more running from law enforcement or something like that, to that effect. So, Mr. Poole, I'm going to set you the normal bond I was set for this misdemeanor charge, which is $2,500. Mr. Poole, that there's no point in making that unless you can make the child support purge too. So you'll see the child support hearing officer in the next couple of days. You'll know if your purge is going to be lowered or not. In the meantime, you've got the right to post everything. And Mr. McDaniel, I think he actually has 2 child support purges, not just one. Is that right?
Correct.
Mr. Poole, do you have any questions?
No, sir.
All right, sir. I wish you the best. We do need to give him a notice for his court date. It would be
August 31st.
August 31st at 9 a.m. Thank you. And we have Mark Clark. Mr. Clark, good morning. You're here because you've been accused of 1 count of driving under the influence. Mr. Clark, there is probable cause in that complaint. And I'm going to appoint the public defender's office to represent you for first appearance purposes. Please listen to Mr. McDaniel.
Your Honor, I spoke to Mr. Clark extensively this morning and went over, possible defenses he has to this and other issues. And at this point in time, he, on his own, he just wants to go ahead and resolve this case. So he's going to plead no contest to the charge of DUI. Understanding that he placed on probation for 11 months, 29 days, $1,078 in fines, 50 hours of community service, minimum driver's license suspension. You have to take a DUI class. You have to take some alcohol training as well. AA, unless he gets that through his DUI class, if he gets signed up within the first 60 days. He will sign his plea waiver form, waive his right to jury trial and call witnesses, and that will resolve this case.
Mr. Clark,
Yes,
I think
sir.
what Mr. McDaniel is talking about is a very unusual DUI. I've never seen one quite like this.
Yes, sir. Me either.
Mr. Gill. So knowing that, I know that Mr. McDaniel's talked to you in detail that there may be some defenses to this case based upon your location in the car, being in the passenger seat, but there's still there's still other evidence against you, and you want to go ahead and resolve it today and get it over with, and not, Mr. McDaniel, not look further into your possible defenses. Is that correct?
That's correct, Your Honor.
And Mr. Gill, is that agreeable with the state?
It is, Your Honor.
Okay, so Mr. Clark, I'm going to accept your plea of no contest. I'll wait till you get through signing that form. That form that you're signing waives your right to a trial. It waives your right to call and cross-examine witnesses and enters your plea of no contest, Mr. Clark.
Okay.
I'm going to accept your plea of no contest to the charge of driving under the influence. The judge you guilty of that offense sentence you to the standard first offender conditions, which are 11 months, 29 days probation, $1,078 court costs and fines. These are all required by state law or state statute or county law. Successfully complete substance abuse counseling and 50 hours of public service work, and DUI school. If you enroll in the DUI school within 60 days, that will satisfy the counseling requirement. If you don't enroll within 60 days, you've got to begin counseling. If you choose AA, we're going to put a cap of 12 classes on there. That will be considered completion. And I do recommend the minimum driver's license suspension. Mr. Clark, you may get off probation early. The way you get off probation early is you do half the probation, you have no violations, and you get everything completed. Mr. Clark, it's hard on a DUI to get off early for most people because the fine is set so high by state law. But if you can get it all taken care of, certainly a possibility that you get off probation early at 6 months or some point earlier than the 12 months if you get everything done. Mr. Clark, what's going to happen next? Is they're going to let you get dressed in your regular clothes. They're going to bring you to the courthouse because that's where the probation office is at. They will let you use the phone before you leave the jail for transportation to call friends or family. And you can tell them you can be picked up at the courthouse in roughly 30 to 45 minutes from now. And that'll be after you get instructed and Mr. Goodson goes over everything with you. Mr. Clark, do you have any questions?
Yeah, how long is the driver's license suspension?
Your first DUI suspension, typically the Department of Highway Safety and Motor Vehicles are going to suspend your license for 6 months. However, you may qualify for a work or business permit after 60 days, Mr. Goodson. There's a 60-day downtime, which you cannot qualify for a permit. But if you've done certain things, including signing up for DUI school within that 60 days, you very, very commonly people will qualify for a business permit after that 60-day downtime. Did I explain that correctly? Any other questions, Mr. Clark?
Yeah, I had disabled family members, so the license suspension is a big deal that can't drive. So,
yeah, Mr. Clark, you understand that there are other options. You don't have to take this plea today, but this is what you're deciding to do. Is this what you want to do? So let Mr. Goodson, I want to make sure you're clear, you understand the option. I know Mr. McDaniel's explained it to you in detail, but Mr. Goodson's I'm going to ask him to explain the process to get that work permit is different if you don't plea. Mr. Goodson, do you mind?
No, sir. So this is his only DUI.
It's only DUI. First DUI, right, Mr. Clark?
Yes, sir.
Okay, listen to Mr. Goodson.
So, Mr. Clark, if you don't plead today, there's a 10-day window that there's certain things that you can do to go ahead and apply for the business permit. Those being, you have to fill out an affidavit and email it to the Driver Improvement Bureau in Panama City. I have that affidavit in my office. Okay. The second thing you have to do is enroll in DUI school. So may I look at his ticket, Judge? So the officer marked the box on your ticket if you don't plead today, and I'm just asking me.
Yeah, I want him to know his, because Mr. McDaniel may not have seen this ticket, so let's make sure you're on the.
You have 10 days to drive with this ticket because the officer marked eligible for permit. So they took your driver's license, I assume, last night, but you can drive for 10 days with this ticket. 10 days from the day you got arrested till midnight, 10 days from then. During that 10-day period, if you enroll in DUI school, which is $360, fill out that affidavit, email those things to the Driver Improvement Bureau in Panama City. In Tallahassee, they should be in contact with you within 2 weeks. So you may be able to get your business permit a lot earlier without having the dead time if you comply with that 10-day rule.
So what some people do, some people go ahead and plead and get over with at first appearance because they don't want to come back to court. Some people, on the other hand, plead not guilty at first appearance, go through that process Mr. Goodson's explaining. Then they may come to court the next month and enter a plea of guilty if they wish, or plea of no contest. And what happens is they will already have the work permit and they kind of bypass the 60-day downtime. Is that right, Mr. Goodson? So it's possible to avoid that 60-day downtime with a law that's been in effect about 2 years. The process that Mr. Goodson's explaining is a pretty new process. So Mr. Clark, Mr. McDaniel's recommended to you that to let him look at this closer, it sounds like, but you have the right to resolve it today by entering a plea of no contest if you wish. So the question is this: you want to take the offer and agreement I've already put on the record, or now that you've had more time to think about it, would you prefer to plead not guilty today and look into it further?
I guess I'll plead not guilty.
Mr. McDaniel, is that your recommendation too?
Yeah, and I know Mr. Clark is a ex-executive, and he has money and stuff, and I know he's retired now, but I think his biggest concern was he's probably going to have to hire an attorney with properties and stuff that he owns. But like I said, if he come in and pled no contest, I mean, he wouldn't have to have an attorney. So I think that's the best option for him to do, is to not plead today.
Mr. Gill, is it safe to assume that as long as his history doesn't change between now and his arraignment date, his plea offer as a first offense DUI will be the same, whether he has an attorney or not? So the offer that's being made to you today is still going to be the same offer that's made to you at your arraignment date, which I'm about to give you, as long as you don't have any charges between now and then.
Okay.
So Mr. Clark, what we're going to do, let's back up. So we're not going to accept the plea today because Mr. Clark, after thinking about it and having some questions answered, does not want to enter that plea today, which is perfectly okay. So what we're going to do is, let me go back to the criminal history. I know you had no prior DUIs. There's a battery from 2011, which is really a non-factor for me for first appearance purposes, and that's it.
Yeah, all of it. Yep.
Well, it was a kidnapping / battery from 2011. That felony, now that is old.
That was dismissed. Okay. I even have a letter saying they were supposed to clear the record.
I see it on here, dropped or abandoned on May 5th of 2011. Therefore, I'm going to let you pick between a bond and a conditional release today. Well, Mr. Gill, any input from the state on, now that we know he's not pleading, on the bond or release options, Mr. Gill?
As a bond analysis, Judge, we're just asking for a reasonable bond that he not be able to possess or consume alcohol during the...
Thank you. So if you want to choose the bond of $2,500 cash or surety, that's fine. If you'd rather accept the conditional release, Mr. Clark, I'm going to offer you that conditional release. Either way, you will have a condition not to possess or consume alcohol because it's an alcohol-based DUI charge that you have. And the bond, again, is cash or surety. Do you have any questions about that choice between bond and conditional release?
Yeah, I've got confused between bond and conditional release.
Yeah, Judge is going to accept the conditional release.
Great. Mr. Clark, what's going to happen next is you're going to use the phone, get you dressed in regular clothes, and you call friends or family if you wish for transportation purposes. If you need to, they can pick you up at the courthouse in about 30 or 45 minutes. The jail's going to get you, once you get dressed, they'll bring you to the courthouse. You'll meet with Mr. Goodson with the probation office. He'll explain the conditional release to you. He also will answer your questions you have about getting that driver's license, may give you some contact information on that. And then you'll be free to leave. We will give you a notice, or the jail will give you a notice. Who gives a notice on conditional releases, the jail or us? We do. We'll give you a notice when you get here for your court date. Your court date will be August 31st at 9 a.m. will be your court date. They'll put that notice in your hand. And you, as Mr. McDaniel said, you may not qualify for the public defender. If you don't think you will, then you can make the choice whether you want to hire an attorney before that court date or whether you just want to come and represent yourself or plead guilty or no contest and waive the right to an attorney. You've got the right to do any of those things. Mr. Clark, it's very important that you stay out of trouble between now and then, including not possessing or using alcohol. Do you have any questions, sir?
No, Your Honor.
All right, sir. Wish you the best. So, Mr. McDaniel, help me think through this. The only downside I see to waiting is you got to come back to court, number one. You got to comply with the conditional release and the possibility of violating the release. Are there other downsides to waiting if someone's in Mr. Clark's situation?
I tried to tell him there was no down. I thought it was any downside was he should wait, you know what I mean? But he just wanted to take care of it because I think he's got some defenses, but I think the only downside sometimes is, as far as what Mr. Stacy is talking about, is I've had a few of them that did this. They still suspended their license, and it was very difficult for them to try to keep their license when they come in after they pled the second, when they come in and pled. Stacy, have you seen that issue or?
I mean, the benefit is this, in my opinion, he's got 10 days he can drive with that ticket. So he can apply for a business permit. He can do that. Basically, all he's got to do is go to Panama City, enroll in the DUI school, show proof of that, email that to the Driver Improvement Bureau. They're going to set him up for a hearing. He's going to get the business permit. The downside is it may take him 2 to 3 weeks because they're hard. You can't get anybody on the phone over there. So what I'm telling people to do is that don't plead at first appearances is to, if they had the ability to pay the $360, I'll help them. We'll email that stuff to Tallahassee. They can get their business permit. If they don't receive a response within a week after those 10 days, I'm telling them to drive over there. They get the business permit. If they come to court 2 months later, they get pleaded to DUI, the business permit is dead. They turn around and apply again and get it back. So there's a benefit, in my opinion, to having somebody have the ability to have a license so they can go to substance abuse counseling. They do 50 hours public service work. They drive and check in with me, and they can drive to DUI school.
So what about, it's a different analysis though if the officer doesn't check that box because the ticket can't count as a license for 10 days,
so
right?
That's exactly right. So on the ticket, it'll say eligible for permit, yes. So when he gets out this morning, he can take that ticket. He can drive for 10 days.
But if the officer did not check the box, he couldn't.
No, sir.
Okay.
He still can apply for the business permit though. He just doesn't have that 10 day.
I guess I've had a couple of them after they pled, like he comes in on August 31st and pleads. They took his license, his business permit again, and they had a difficult time trying to get it back. Have you seen that?
Right. That's why I'm telling them to drive back over there. And which I know that's difficult. I'm not saying it isn't, but the problem is getting them to correspondence with them to answer the phone. That's a difficult problem. Yes, that is difficult.
But that helps me understand better. So, gentlemen, I do have a calendar issue to let you know about for 2027's calendar. It's going to take about 2 minutes, if that. Anything else on the record, Mr. McDaniel?
Nothing else, Sean.
Sarge, anything else from jail?
No, sir.
Mr. Gill?
No, Your Honor.
All right, so ladies and gentlemen, that concludes first appearances for today, July.
Okie dokie, friends. That ends it for Wade Mercer for the day. Good morning once again. Now in hour 2 of TCF Live on this Super Friday. Again, in hour 3, we will have an announcement for you, so do stick around for that. Let's do something different. Let's go to Wisconsin, and let's check in with their Governor's Pardon Advisory Board. Let's see what that's all about.
We can. We don't have video quite yet. Okay. There we are.
Okay. Hi, everybody. All right. My name is Marina Johnson. Back in 2009, I was charged with party to a crime, robbery with the use of force. I was only 16 years old. I got sentenced to 6 months Hubert, so work release, and then also 3 years of probation. I did successfully, did probation and everything I needed to do. Since then, I have been working as a collision estimator for 12 years. I absolutely love my job. So since then, I've just been, working. I became a mother of 3 as well during this process. And then for the community based, during the summer, I usually give back to the community by working with Running Rebels with the basketball team for the summer with my 2 young boys. So for that, I try to give back every summer to the community. But other than that, what I'm looking to get out of here is hopefully I can get my expungement so I can further along my career here at my job with my boss and see how life brings me having a clean record for once.
Sorry. Thank you, Ms. Johnson. We'll open up to questions from the board.
Thank you.
Judge Carvers.
Good morning, Ms. Johnson. I have just a couple of questions. You were ordered to make restitution in this case. Did you pay restitution?
Yes, everything was finalized. I'm not for sure how long, but it's been a while since I successfully paid restitution.
Do you remember how much you paid?
I want to say it was like $1,000.
Okay. And then my other question is, In your application, you seem to suggest that you just didn't have any idea that there was going to be a robbery, that you were just.
Correct. Yeah, I didn't go with them to do a robbery. I was just there as a friend, as always, with two friends. I thought that was my friends at the time.
In the complaint, though, it says you gave a statement to the police where you acknowledged knowing about the robbery and that they showed you the gun and talked about their plans before they went in.
Yeah, that's was something at that time. I was only 16 years old. I just agreed with anything they needed me to agree on. I just went, just me being nervous, being 16 years old, still in school. I just went along with anybody needed me to say, just so I can see, go along with what would happen. At that time, I had no lawyers present, no family present. It literally was just me, myself, and I during this whole process.
Okay, thank you.
Cindy.
Yeah, just for clarification, it appears from the record you were 17 years old. The crime happened November 15th of 2008.
Yes,
definitely
a long time ago. No problem. It's been a long time. I don't even remember.
I understand that. I just like to get the facts correct.
Thank you.
So a couple of questions from me as well. First of all, letters of support are encouraged. They're not required, but you chose not to submit any letters of support with your application. Can you tell us why not?
For one, this is my third time submitting the application, so I don't know. I know the first time I did have letters of recommendation from my bosses and family members at that time. So between that time of me submitting my first application to now is almost like 4 years later. I'm not for sure why you guys did not have that information.
Ms. Johnson.
Go ahead, sir. Sorry.
I'm sorry, I just want to clarify. We do have a record of you applying during Governor Walker's administration around in 2018. Are you saying that you've applied previously while Governor Evers has been governor?
Correct. And then I got a letter probably last year stating that you guys only needed 2 documentation from me. And I never received saying that you guys needed the additional recommendation because I thought everything was from the first governor. Sorry.
Yeah, that would be your current application. It was a long time ago, but that would have been what we've been reaching out about.
Gotcha.
Okay. I'm sorry, Cindy, please continue.
No, thank you, Chair, for clarifying. What's your current employment? I see you have a logo on your shirt. Who do you work for now?
I work for Crash Champions.
And how long have you worked for them?
I've been with this company for a year. I just transferred from Rosdero over to here.
So in your application, it said you changed jobs to Collision Estimates. Is that the same company or is that a different company?
Collision Estimator is the job, is my job title.
Your job title for this company?
Correct. Yes, ma'am.
Got it. Okay. And then it looks like in 2024, you had a deferred prosecution on a misdemeanor battery. Can you?
Correct. My son at the time was 13 years old. We moved to Washington County, wanted to, move the kids out of the inner city to, show them something different. My son at the time was having issues of getting comfortable in Washington County. So I had a lot of issues with him going to school, things like that. I was charged, they were trying to charge me with child abuse. So after that, when they found out there wasn't really no case, they just told me to do, a 1 year, make sure I don't get into no trouble, take parenting classes. And then I successfully did that recently last year.
But what was your behavior that resulted in a misdemeanor battery deferred?
Well, according to the police, my son ran away from home because he was scared with what I would do from him getting suspended from school.
And what behaviors did you do? You say according to the police.
According to me, I just did disciplinary action to my son. So I gave him a disciplinary action of giving him a whooping. And according to the police out there, they wanted to charge you with felony child abuse.
Okay, thank you.
No problem.
Other questions from the board? Okay, I think that's it for Ms. Johnson. I appreciate your time this morning and I hope you have a great Friday.
Thank you. You too.
Thank you. Next up, we have Randy Parker. Mr. Parker.
morning, everybody.
Good morning.
I believe it was 2010, when I got in trouble with this case. Basically, I was out at a party with my friends. A fight ensued. There were some guys assaulted. I was there. I had nothing to do with the assault. I was just a bystander. So when everything went down, I went to court to, try to explain everything from my perspective, and I wound up being charged with party to a crime. I never struck anybody. Like I said in the beginning, I believe all this happened because I just lied, because I wanted nothing to do with it anyway, because like I said, I just stood there. So when they asked me was I there, I was saying I wasn't there. Basically, it's just, I got in all this trouble for lying. I never assaulted anybody. So far as job employment, I've been up and down with jobs from 2010 to now. I did in-home care for maybe like 4 years, and I left that job because I couldn't get a promotion because of the charges that I had. And my boss just was like, well, we can't promote you with these charges, so you need to try to fix this. So just was a whole mess with me trying to find jobs. I hadn't offended before then. I had only a marijuana charge before then from maybe like 2006, and I haven't offended since then. So now I work for a daycare, janitorial services. I've been doing that maybe like 3 years, maybe 4 years. I just feel like if I could get this part, it would help me be able to be a better person, not only for my family, a provider, and, just to be able to live life without this hanging over my head. I just feel like the whole incident stemmed from the district attorney or the prosecutor, whoever she was, just looking at me at that time. I hadn't gotten any trouble, and it was like, I felt like she had it out for me. Like she wasn't gonna let me leave the situation without a felony. It was 10 charges, and I only got charged with perjury. That was my charge, perjury to the court, because I lied about the whole situation. And like I said again, I hadn't offended before then, besides the marijuana charge, and I haven't gotten any trouble since then.
Thank you, Mr. Parker. We'll open up to questions from the board. Judge Kremers.
Good morning, Mr. Parker. So let's talk about this incident. You were originally charged with all 10 charges.
Correct.
Right. And that's because you told the police, according to the complaint, that this was a plan to go into this residence where you weren't invited to get back a TV set that supposedly belonged to one of your group that invaded this party. Is that right?
No, I never told police there was a plan for that.
You didn't tell the police, because in the complaint it says that that's what the plan was, to go in there to get this TV set, and then once you got inside, there was a physical altercation, and that you didn't take part in the physical altercation, but you were part of the group that went into the place that started this. You didn't tell the police that?
No, I didn't. I told them that I was there. First, I told them I wasn't there. Then I told them I was there, and they went there. I just got asked to ride with them. I had no idea why they were even going there.
Okay.
I was just going with my friends. Like I said, in the beginning, this all started because of a lie that I told. I didn't participate in anything. I was just there. And once I seen what everything happened, I didn't want nothing to do with anything. So I just basically tried to keep my mouth closed until I came to court to try to help my friend.
Right. So when you talked about lying, that's you lied on the stand in the trial of
Correct.
Friends.
Correct.
Okay. Thank you. Any other questions?
Reverend Hancock.
Mr. Parker, the judge in Dane County who reviewed your application for a pardon supports your getting a pardon. Now, the decision will be up to the governor, but how does the judge's support make you feel?
That is actually shocking to me, but I mean, it means a lot that I have the judge's support.
Okay, thank you.
Cindy?
Yeah, good morning, Mr. Parker. I want to go back to the crime as well. In your application where you described the crime, you said, this is a sentence you wrote, there was a fight, and while no one was seriously hurt, someone's wallet was stolen. I read the criminal complaint. First of all, the people in their own house that was invaded were kicked in the head. They were hit with glass bottles. At least one was knocked unconscious. At least one person got stitches. They were terrorized by having guns pointed at them. How is it that you can characterize that as no one was hurt? This doesn't even describe the emotional trauma for people having their home invaded. So can you speak to why you characterize this as no one was hurt?
Because I didn't physically see that because I never entered the home. So when they were telling me everything that happened, I thought it was just a fist fight until it all came out. So I'm like, a fist fight, okay, people, you might get punched, you might get, I didn't know anything until after.
But now you know, and when you filled out this application, you knew.
Yes.
And you still characterize it as there was a fight and no one was seriously hurt.
I mean, that's just my stance on the situation. I don't believe anybody was seriously hurt because no one went to the hospital. I didn't even realize that someone had stitches and everything. Like I say again, until I read everything, but I mean, you can get stitches falling and hurting yourself. I just didn't look at the incident so far as that is like no one lost their life. I didn't even know a lot of other things. I'm still finding out things today that happened from the incident.
Thank you.
Other questions from the board? Mr. Parker, just one for me. As you pointed out, you don't get charged with the original charges you had in those cases. This get dropped, and what you are charged with is perjury. What I heard you say at the beginning is kind of all I did was lie, and the DA wanted to stick something on me. So is that? Can you just talk a little bit about reflecting back on this now, the impact that might have had on the case and the justice system and the folks who were trying to get the truth of what happened here out in court?
Oh, no, I totally get that. I should have been, first of all, I shouldn't have been there. And I should have been more forthcoming with information, seeing as I didn't go there for that. But again, not wanting to, I guess, tell on my friends or people who I thought were my friends. After I tried to stay out of it, I just lied. But I know today, or I knew then, but I didn't use my conscious decision to tell the truth about the situation. But I understand the gravity of this situation.
Okay, thank you. I think that's it from questions for us. So thank you for your time this morning, Mr. Parker, and I hope you enjoy the rest of your Friday.
All right, you guys have a good day.
Thank you.
All right, I'm going to pause here for a minute, and I think we'll watch one or two more of these perhaps, because this isn't a place we've been before, so it's interesting to explore it. But I pulled up information on this board because tell me if you disagree, but this is totally different from what we see down in Louisiana. But I wanted to get a feel for the cast of characters. So Mel Barnes, who is obviously kind of hosting this thing, she is the chair and chief legal counsel to the governor. So she kind of runs the show for him. Cindy O'Donnell, who was, doesn't look like she's on the screen at the moment, but she was, is a vice/corrections veteran and former Department of Corrections deputy secretary. Jerry Hancock is Reverend Jerry Hancock. He is the director of the Prison Ministry Project and former public defender. Eric up there is a paralegal studies professor and former supervising attorney at the Disability Rights Wisconsin. And Jeffrey Kremers is a retired judge, a circuit judge out of Milwaukee County, where he served 25 plus years. So what I find interesting and why I wanted to share this is a very balanced board, I think. That's my opinion on it anyways. There's people from a lot of different backgrounds, and it's not all old people either. Mel and Eric are not elderly. Like that's pretty much all we see in Louisiana. So anyways, I just wanted to share that. Let's go back and watch one or two more, and then we'll move on.
Thank you. Next up, we have Harrison Switchenberg. Mr. Switchenberg.
Yes, I am here. My apologies.
No problem. Go right ahead.
Good morning. My name is Harrison E. Switzenberg. In 2016, I was charged and then a few months later convicted of manufacturing and distribution of a Schedule 4 non-narcotic by the name of clonazepam that I had a prescription for. I completed my sentence, which was probation. I actually got sober in jail for the 89 days that I sat awaiting my bond hearing. And since then, I have been able to obtain primary placement and sole custody of my daughter, obtained my driver's license. I have maintained my sobriety as well. I work with people who have PTSD and who were abused, who are struggling with substance abuse themselves. It's been a hard road in a lot of ways, but I'm grateful for it. I put a lot of hard work into not just myself, but also my community and outside of my community, trying to help people find their way to work through their addiction, to work through their trauma. And I would be honored to get a pardon. I believe that it would help me pursue what I'm trying to do in the spiritual and emotional healing aspects, and in the fitness and nutritional industry as well, which I have also been pursuing the last many years, trying to be a good role model and inspiration for people trying to just live a healthier, better life. And I think that it would also be a huge inspiration to the other people that are struggling with addiction or their sobriety, to see that, you know, you can be successful, that you can be acknowledged for that, and that you can help the world around you and be a positive influence, and that change is actually possible no matter what you've been through and no matter what you've done.
Thank you, Mr. Switchenberg. Questions from the board? Eric.
Good morning. Thank you for taking the time to talk with us today.
Thank you for having me.
Just wanted to ask you a little bit more about some of the work you're doing in the community. I appreciate you sharing about how you're helping individuals who have experienced trauma and the link to substance misuse. Is that through a formal organization? Is that kind of informal mentoring? Just any more details about that you're willing to share?
It's more informal, where people have heard about my success with sobriety, known my background and how deep into addiction I was, and seeing that I was able to get out and, you know, coming to me for advice on how to work through their trauma and their abuse and how to stay sober, things that they can do to, you know, maintain their sobriety as well, because getting sober can be the easy part. Staying sober for the long term is the hard part, and seeing that I've been able to do that for a decade now is very inspiring, and just giving people the tools that they need to not just get, but maintain their sobriety, which is the most important part.
All right. Thank you for your response, and congratulations on your sobriety.
Thank you very much.
Reverend Hancock.
Just to follow up, how do you maintain your sobriety?
I maintain my sobriety in a multitude of different ways. I notice I'm very a busy-bodied person. I like to be active, so I train daily, sometimes twice a day. I go on long hikes. I talk to people in and outside of the community. I am intellectual, so I love to learn about anything and everything, literally. I spend a lot of time learning. I do meditation practices. I'm very self-aware about my feelings and how I'm feeling, what I'm going through, working through things in the moment. Whether it's a good day or bad day, I like to take those steps back and realize, just how grateful I am and how appreciative I am to be alive, and that I can do this and I can experience this beautiful life and not just have a positive impact on the world around me, but also enjoy it along the way and see people grow and bring people together and be able to connect and communicate with people on a deeper level.
And in your application, you indicated that you're receiving disability. How does your disability affect your sobriety?
My disability doesn't affect my sobriety negatively. I think that, honestly, at this point, working into doing something better is a huge motivator, and the pardon would help that. But I don't think that that's negatively impacted it at all. I think that it possibly could have helped at the beginning as well.
Okay. And one minor question about the offense.
Yes.
In your application, you say you gave the pills to your friend.
I did.
She says she bought the pills from you.
A discrepancy that I would love to rectify. I know that we shared a lot, and that we had a group of friends that, we did. We abused substances, and things just kind of went around. That is her side of it. I know that I was very giving. They were very giving. She was very giving as well when we were friends.
Okay. Thank you.
Yep.
Judge Connors.
So it looks like, sir, that you have several domestic violence related convictions from 2012, 2014. Can you talk about what those were about?
Yes, I have two of them, and they were in Grant County, and they were between me and my grandmother having disputes about money. We used to own a shop, my grandfather's metalwork shop, which before that used to be my great uncle Carl and my grandfather's gas station, where we build metal artwork. Ellis Nelson, he's very well known for that all over the world. And at the time, it was me and my grandfather and my uncle Thomas Nelson who built the artwork and had a really good time doing that. And it was a dispute over money. And when the authorities showed up, it was William Schramm, the sheriff at the time. He said, I sympathize with you. The cops were called. Something has to happen. She is the elder, and you are in your 20s, so we're going to take you. I'm not going to take an elderly woman to jail. That there has to be a resolution here, and this is it. And then that same thing happened again since I was on bond. There was a disagreement yet again about money, and then that ended up resulting in me going back because I was already on bond. So they said, you already have a charge over you, and that we're just going to take you again.
Well, when you say a dispute over money, it must have been, did it get physical? I mean,
No. It was strictly verbal, where my grandmother wanted some money from me and my uncle, and what we gave her wasn't enough. She would, not be happy with what we gave her, and she would get loud and make it very vocal that it's her shop, it's her husband. And, I take full responsibility and accountability for my part in it. It was a family squabble that got loud. The neighbor called the cops, and unfortunately, it did result in something more than it needed to be. It looks a lot worse than it actually was. It was just a typical family dispute, really.
And your probation was extended in 2017. Why was that?
In 2017, can you elaborate?
No, I'm asking you to elaborate. Why was your probation extended?
In 2017?
Yes.
Well, I was given 3 years probation for the crime that I committed in 2016. From 2016 until 2019, when I got off of probation successfully. I'm not aware of an extension because I was given through William Andrew Sharp, who was my convicting judge, gave me 3 years probation. And that was in November of 2016. And I completed that in November of 2019. I'm not aware of any extension because I had 3 years to serve anyway, and I've served them successfully.
Was your probation on your misdemeanor, your underlying misdemeanor, was that extended?
I'm not sure. I know that the felony charge that I applied for a pardon for was why I got my probation. I know that I have charges read in and dismissed, but I didn't have any hang up while I was on probation. I actually met a very good agent in Grant County that helped me a lot in that time. So I'm sorry, I can't answer it effectively because I'm not sure what that would be about. I wasn't made aware of that. Nobody communicated anything to me like that at all when I was on probation.
Okay, thank you.
Yes.
Cindy?
Good morning, sir.
Good morning.
As part of the application process, applicants are encouraged to submit letters of support.
Yep.
So you chose not to, and then also in your application, section 16 talks about community service activities you participated in. We're looking for ways people have given back to the community.
Okay.
And so you put not applicable, no letters of support. Why not?
The not applicable would be because it wasn't anything formal. This is all people coming to me and me reaching out to people. And a lot of them would remain anonymous for people that I've helped or came to me. As far as the letters of recommendation, that was a massive oversight on my part. In fact, last night I was watching the July 10th hearings, and I knew that this question was coming. That I didn't realize that was part of the application process, because I have north of 40 people that I could have got letters of recommendation from, some being arresting officers, local law enforcement, the chief, the sheriff, veterans, friends, family, the judge, the convicting judge. And when I heard that last night, the first time it came up, I was like, oh, yeah, that is a massive oversight on my part. And that was a huge mistake.
Okay. If you've watched, you've heard.
Yeah.
It's very helpful for the board because you want us to see who you are today, not who you were back then. And so those letters, whether they're from family or neighbors or whatever, they're very helpful for the board. But thank you.
Yes, thank you.
All right. Thank you, Mr. Schwichtenberg. I think that covers it from us. Appreciate your time today, and I hope you enjoy your weekend.
Thank you. Have a beautiful weekend. Bye.
Thank you. Next up, we have Everett Lawrence. Mr. Lawrence?
Okay, just an FYI, we're going to do one more of these, and then we will move on to something else. But just so you understand, this particular board, they only meet every other week. So we won't see them again until the 14th. So this will not be something that we see all the time here at TCF, which is why I'm willing to stick with it a little while longer, especially because it's new to us. But just an FYI, we don't see them again until the 14th, 2 weeks from today. So there you go. Let's do one more.
Okay, I do not see Mr. Lawrence in the Zoom. So we will come back to him if he joins, and in the meantime, move on to Antonio Jones. Mr. Jones.
Hello?
Hello.
Okay, 1 second here. Okay. Is that it? Can we see there?
Yep, perfect.
Okay. Hello, good morning. Good morning.
Good morning.
So, hi, my name is Antonio Jones. At 17, I was convicted of delivering a controlled substance. I come from a single family home. I was raised by my mom. And when I went outside, I was influenced, honestly. I was around the corner from my house at a dope house. I knew that it was a dope house. The guys in the neighborhood hanged out at that place, and it was kind of a kicking it spot. So the place was raided, and I went to jail, and I was charged with delivering a controlled substance, conspiracy of delivering a controlled substance, because the substance was delivered under the door and the officers couldn't see who sold it to them. So I'm thinking that's where the conspiracy charge came from. But once they came in, I told them that it was me who served the drugs under the door. I went to jail. I was 17, about to be 18. I was given 10 years for that. I was given 1 year in the house correction and 9 years probation. So after that, my life of just up and down, in and out of jail started. Honestly, lost no one to look up to for guidance when it came to any type of structure or what I should be doing with my life at that moment. To be honest, and I hate to say this on camera, but going to prison was the best thing that happened to me. After I figured out what it was I was supposed to be doing with my life. So I went in and out for a few years, back and forth. The last time I went to prison, I did 30 months. And during that time, I really sat with myself. And I was just like, what am I doing? Who am I? What am I supposed to be doing? And that's where my life changed. So when I was released from prison that time, this beautiful woman, she's a pastor. Her name is Pastor Cheryl Brown. She gave me an opportunity. And I took full advantage of that opportunity. She let me work. Well, while in prison, I obtained my HSED. So when I came out, she allowed me to work at a school, which is Believers in Christ Christian Academy. I was a teacher's aide. I was working in a school with the kids for 5 years. And that was my form of giving back. It completely changed me as a human. I loved it. I did it for 5 years. After that ended, I transitioned to what I do now. Well, I do multiple things now, but I'm a fitness coach. I do that every day. And I have at least 17 clients that I work with every week throughout the week. I also have my dealer's license. So I run and I do my wholesale with my cars. I buy them from one auction, sell them at another auction. I've also started RG Logistics, which is a company where I drop off items I go to this warehouse, pick up the items, and then I drop them off. My son and we do that day to day. I love it. I do. I love who I am today. I love what I do today. And with everyone who speaks to me, or should I say everyone I speak to, I want to be able to tell them, hey, I've done this, that, and the third, and it was negatively. But those negative things have prompted me to be the person I am today. The person I am today, I'm able to reach back and dig for other people who didn't have that guidance who didn't have the guidance that I didn't have. And when I see that, I'm able to help from that place. But I enjoy who I am today. I love it. I wouldn't take back any of these things because it made me who I am today. I honestly believe it made me better.
Thank you, Mr. Jones. Let's open up to questions from the board. Board members? Cindy.
Good morning, Mr. Jones.
Good morning.
So you're asking today to be pardoned for 4 different felonies that happened from the ages of 17 to 23.
Yes,
6
ma'am.
right? Okay. So here's my question for you. The first one, you put on probation for a long time. You get a year in jail. You engaged in criminal conduct again, fleeing and eluding. And there was a shot fired from a gun. You say accidentally, you were climbing over a fence, I think.
Yes.
When the shot fired, but certainly endangered people in the area. You get prison for that.
Absolutely.
Then you're on work release. You get the privilege of being out on work release, and you don't come back.
Just still lost.
I know. Just let me finish this arc. No, you know the story, but let me just finish. You don't come back from work release, so you get an escape charge. And then again, in the last one, 2006, you again fleeing, going 60 miles an hour through stop signs. I mean, the danger to the community. So what probation didn't change you, prison didn't change your work release. What was it that made you change at 23 to say, I'm done now, I'm done?
It was a guy that I looked up to in prison. I don't know why, I just looked up to him, but he went to court and they gave him boot camp. And that guy came back and I'm sitting out on the courtyard and I'm looking at him and he's speaking to other guys and he said, yeah, man, they gave me boot camp and earned release, but I'm going to save it for my next prison. I'm going to save it for next time. And when I heard him say that, I'm just like, dude, I do not want to go out like that. I do not want to waste my life in prison. Like, I just don't. So instead of sitting around playing the cards and the dominoes, I immediately went and started educating myself. I went to school every day. I went to the gym. Anything that prompted me building on me, that's just what I did. And I've been doing it ever since.
Yeah, and congrats on your HSED and engaging in those things that could change. You report that you've been sober since 2009.
Yes.
Right? Okay. How do you, maybe through fitness, but how do you maintain it?
Fitness is my source of therapy. It's everything to me. Like, my wife was just telling me, like, you'll lose your mind without that gym. Because whenever I'm in a space where I'm just kind of like unsure, shaky, wavery, that's my solitude. Like, that's my place where I go and I figure it out. Whether I'm doing it for an hour and a half, 2 hours, that's my source of therapy. But it helps me throughout everything.
Okay.
It really does.
Thank you.
Thank you.
Judge Kremers?
Good morning, sir. I want to talk about what appears to be a series of tax and unemployment compensation warrants against you by Milwaukee County.
Say it again, sir.
So it looks like, and admittedly, you have a fairly common last name. So I just want to ask you about these. There's in 2025, an unsatisfied unemployment compensation benefit warrant against you for $49,000. Do you know anything about that?
Absolutely not. No.
Do you have any delinquent tax warrants or unemployment compensation warrants that you're aware of?
No, sir. Not at all.
What about see. Any judgments against you by the city of Milwaukee for like $900 or $440? Do you know anything about those?
No.
Did you try and change your name in 2018?
I did. I started that process. I was about to change my name to Akeem.
Okay.
Yes.
That one was dismissed. So I don't know, as you're sitting right here, I just have a list of these record entries, but like I said, your last name is certainly not uncommon. So, but you, as far as you know, none of those tax warrants, unemployment compensation warrants are yours.
No, no, sir. Haven't had any tax issues or anything like that.
Okay. And then the other question I have, 2013, were you arrested for a felony strangulation and suffocation domestic violence case?
2013?
Yes.
I remember in 2013, my sister and I had a verbal disagreement. It did get loud, it got vulgar. I went down to the district. I went to the district for a few hours and then I went home. But I didn't go to jail or have a
Yeah,
conviction.
no, it says you weren't prosecuted. I was just trying to find out what the background story was, but you said it was you and your sister?
Yeah, that was me and my sister. At my mom's house. I think it was some type of gathering. We got into a verbal disagreement. Yeah, it got heated that day. I remember that. And I went down to the district and then I went home later on that evening.
Okay. Thank you very much.
Thank you.
Reverend Hancock?
Mr. Jones, that's a pretty inspiring prison story. And just where were you in prison when that happened?
I was in Sturtevant in Racine.
Yeah, okay.
Yes.
Okay, thanks.
Okay.
Any other questions from the board? Okay. Thank you, Mr. Jones. That's everything from us. We appreciate your time and hope you enjoy the rest of your Friday.
You too. You guys enjoy your Friday. Thank you.
Thank you.
Alrighty, friends, there you have it. The first ever time on TCF for the State of Wisconsin Governor's Pardon Advisory Board. Again, they run every 2 weeks, so we might look at them as a every other Friday thing. We'll see how it goes. But I personally appreciated seeing something different from what we see in Louisiana with the board. So, good times. Okie dokie, let's change it up, though. Let's go to Texas, Judge Stevens.
So days with Henry. Sorry? The old days with Henry. Yes. Now, the blink of an eye. You know, blink of an eye. I'll bet you dare. Yeah, that's soft place with the trainer. Thank you. Anyway, what are we going to do today? Well, I'm just Jimmy, now he's a fair guy.
All right, so Judge, what's come to my attention this morning is that Mr. Coe does not have the offense material that we have on this new matter.
You're talking about this controlled substance deal?
Yes, sir.
What is this, by the way? What are we talking about? It's not identified. What is the controlled substance?
Methamphetamine. Yeah, it's been tested. So Jasper has not indicted this new charge yet, so we don't have complete access to discovery.
I remember I've got some, but I don't have a video, can't say video, but I've got some new also, which is just a little bit more than the skills we got, but you said, yeah.
I'm looking at my material. I have 82 pages worth of material.
Right.
And I see from this, from our discovery website that you haven't gotten it. So, I need to get him that access, and my understanding, the indictment has not occurred in Jasper because the drugs have not been officially tested. And so what, just to complete the thought process here, she's doing well as far as what the probation officer is telling me. She's wearing the drug patch. I would prefer to reset this.
You've got a drug patch now? Okay. So you didn't have a drug patch
I got it.
here? Hold on.
No, you ordered
it on
it
July 17th.
Good. You ordered it back in September of last year.
Okay, so it was the drug patch that showed up positive?
No, sir.
So,
No, it was the arrest and the charge in Jasper that resulted in this motion, Judge. But to my understanding, she hasn't had any positive results from the drug patch that she's been wearing for about 10 to 11 months now.
I don't have a summary of this incident here in that. Yeah, that's what I thought. Oh, stand by. I do.
I think about it. I knew they were mad at the
So the suspected drugs were in on a motorcycle.
Yes. Yes, sir.
And quick plastic baggie was in the left saddlebag.
Yes. Yes, sir.
And then it goes neither the occupant and the operator, who was a male, accepted possession for those controlled substances. So I guess they were both charged.
That's correct, Judge.
Oh,
And I don't know why I had anything to get a big call up there, as always, just the part of the sound and law.
Our understanding is that they're waiting for the drug test results to come back, Judge. I see where it's been submitted. I don't see where the test results.
So today, what do we want to do?
Judge, I would recommend a little bit longer reset than what you normally do so that we can see how Jasper sorts it out.
What do you think?
I would say at least 60 days, just because of just knowing what the drug test results are.
Okay, let's let them ferret that out, and if it has to come to me to resolve it, but
She's doing well otherwise, so I'm very hopeful that it can be resolved, Judge.
and the other, the operator was charged as well.
Yes, sir.
And what's the status on his case?
Same, because they're still waiting on the drug test result.
But I mean, it's just a pending charge. He's not on probation.
I have not looked up for him, Judge. My concern is
I didn't ask about his case, as I probably should have, but I just said.
That's okay. Well, it's findable. Okay. All right, reset then 60 days. Thank you. Yes, sir. Yeah, get a resetting. Here, Henry.
You're on.
Yes, from her. Get a resetting. Dustin. Broussard. Rodney.
Oh, yes. Judge, if you'll give me a minute on that one, that was popped up on the docket. Yeah, from off docket. I don't know.
NPRP status.
Yes, but
okay.
It's been off docket. I think maybe he was in some other location, but now it's on docket, and I haven't had a chance to look at. Kind of popped up on this one popped up on.
So let's see. We've got a first amended NTRP that's been for a long time.
Right, but
and
he was off docket for.
He pleaded true to something. But what did we just hold that in abeyance? Is that what? He's pleading true to 4.
Let's see what she just did.
I don't know. I need to get everybody together.
I didn't figure it out. He was off docket.
Justin.
Judge.
By the way, Rodney Broussard, here's the deal. He's got 3 matters.
Yeah, he's here.
We got 3 matters. That's the.
So
I just talked to probation. She said he just got out of safety. He's good. She's okay with continuing him on probation if we want to bring the officer up, Judge.
This popped up on me off docket. I just really didn't know what's going on.
It was a status hearing, so she says he's good to continue on probation.
There were, where is it? You or Rodney Broussard? A year ago, over a year ago, you pleaded true to allegation for failing to report to the probation office. And that's in all 3 cases. That was a part of a first amendment motion to revoke unadjudicated probation and continues on probation and to see how things would work out. You are on probation for 10 years. And we're only 2 years into this. So is everybody saying let's let him continue on probation?
He's doing great. He's
That's good.
actually my star pupil for safety.
Oh, look, you're the teacher's
He's getting
pet.
out. He's getting out of safety the whole continuum on September 4th at 6 months instead of the 9 months, and he's
Okay, what do we do with the first amended motion to revoke unadjudicated probation in each of these cases that he pleaded true to? Why don't we hold this until that point in time does well, reward him, dismiss these things, these motions, and just
Come back in the docket. If
Right.
The thing motion will have to have a second.
So you don't want to dismiss the motions now, Judge?
Well, I like this idea about there's something coming up here
yes, sir, on September 4th.
on September, which is just like a month or so later.
Yes, sir.
And then the thing is that I can dismiss these things in a third, which is 3 1/3 years.
Sure.
You can do the math on where you are on that. But these are the cases you don't want convictions, and you certainly don't want 3 third-degree felons. That's 30 years prison. So there's a good reason to run through the tape here. All right, let's look at it right after this. Let's set it. When is in August? You said
September 4th.
September 4th. Okay, right after September 4th, bring him back, and we'll update review, and then see what rewards are in store.
Sir,
You need a resetting. Wrong. Benjamin Roll.
He's present. Present judge. Pointing out.
Okay. On
no worries.
2 weeks ago, a first amended motion to revoke unadjudicated probation was filed. Here, you're Benjamin Figueroa, and clause number 24 CR 807, and this. There was an original motion filed about a year ago, September 25th of last year. There was no action taken on that, I don't see. And then July, 2 weeks ago, a first amended motion was filed. And now we've got 5 allegations pending of DWI, evading arrest, disorderly conduct, failing to provide community service, and then rounding out the field, recent resisting arrest or search. Okay. What are we gonna do about all this?
State's ready to proceed with hearing, Judge. I have 2 witnesses here, including the law enforcement officer, Judge.
Judge, that's what we're here for, but I don't think we can move forward today. There's discovery issues. These are new offenses. The government has the videos and the offense reports on these, but I have not been given them yet.
Well, what are you doing together? Because this first motion was filed September, almost a year ago.
So
what do you need on those for?
I filed a motion for discovery at that point in time. It's been filed. The states have. This case has been reset for about 9 months because the government didn't have these cases. There was no discovery. There was no cases. Now they have.
I don't understand what that means.
These are based
they
on
filed something.
No, they didn't.
Well, no, something was filed in September alleging these.
Correct. The motion
last year.
Correct. The motion.
Well, how are they filing something without information?
Judge, if Mr. Galmore would have made me aware that he didn't have the discovery, I would have certainly made it available.
The discovery request was made in October of 2000.
I shouldn't be directing y'all to get each other information so we can move forward. This is going on a year. That's too long for me.
Yes, sir.
Get this fixed.
Yes, sir.
Y'all got 3 weeks. Get ready.
All right.
Tyler Berry.
Here you go. How are you this morning?
I am fine, sir. How about you?
I'm doing all right.
Let's see. Where are you coming from?
Fort Worth.
Look at you.
I'm all the way down here this morning, just to see y'all.
You wearing boots?
No, sir.
Oh, that's not right.
I'll wear them this evening. It's Friday night.
Oh, that's special for Friday. Let's see. I'll make sure you want to. All right, we've got a motion to revoke unadjudicated probation in this cause number 23 CR 1669, the state of Texas versus Tyler Christian Berry. That's you, sir? Okay. And, you know, it's alleged you committed the offense of solicitation on or about September 5th, 2025 in Dallas County, Texas, in violation of condition 1. That's what's alleged in paragraph 1, and then failing to report to the probation office on or about October 9th, 2025. Those are the two allegations. Where's the probation officer on? Do we have a probation representative on this? It looks like he's being supervised up there, but do we have a contact?
Actually, Judge, they've changed that. He's now being supervised here.
I guess because the motion was filed. I guess they did that.
And he's got a GPS on.
Okay. Robert Menard.
Actually.
Is the officer, it shows, but that was a year ago.
Yeah, it is a new officer, but you want me to give her here?
Yeah, we need to know where we stand on things. Because it's, you know, this was filed in January and I don't like motions to
Judge, he has a new case.
stay in place.
The defendant has a new case out of Dallas County. I reached out to them.
Or
The same offense he's on our probation for.
a different act, a different time?
Yes, sir.
Really?
I reached out to Dallas County and they told me it was still under, well, the grand jury has not reviewed it yet.
Did you know?
Yes, Judge. Dallas is notoriously slow. But I think if we can reset this case, I've got a feeling it's going to resolve itself at the next setting.
How? What is your master plan, do you think?
I made an offer. Defense counsel made a counter offer.
And I'm going to beg and borrow and plead some more.
He said he was going to send me some information to show that the defendant has been taking steps to mitigate his issue with the reason why he keeps committing the same offense. So I'm waiting on the mitigation packet to consider that.
Got my interest up. But you know, the worst thing is to commit a crime while on probation. That's pretty much the worst thing. So you don't want to do that. And you're looking at a state jail felony, which carries with it up to 2 years in the state jail. And that's it. I'm looking at the indictment. I don't see any other convictions. You don't want a felony conviction. You know how long a felony conviction stays on your record? The rest of your life. Okay. So how much time?
See if we're looking at
4 weeks good?
4 weeks is good. I'll get it handled in 4 weeks. I'll yell at Dallas. She'll yell at Dallas. Tyler
Dallas yelling going.
I don't know if it's going to work, but
they didn't. It won't work.
Well, I think y'all are smart enough to.
I think we can work
somehow. Okay, without the crowd in Dallas delaying things. Okay, let's get a resetting. And the most important thing is follow the rules of probation. Okay. You don't want to compound problems.
Thank you, Judge.
Okay, thank you.
Off you go.
Get a reset. Yeah.
Thank you.
It didn't matter.
Hey, Marvin, Dante Perkins. There's two cases.
Right. We're on the bond hearing,
Is that what we're doing?
Yes, sir. I have one witness to be shooting, but I have.
Okay, where is he in custody? All right, take care of Dante and Rife, you've got some things next. Dante's. All right, these are not motions to revoke probation. These are new cases.
New cases.
What? Two cases are called 26 CR 975 and 978, the state of Texas versus Dante Perkins. Is that you?
Yes, sir.
Present with your attorney, Mr. Lewis, and the state's prosecutor is here. You were charged in each of these cases with the same, the similar type of offense, deadly conduct, discharging a firearm. In 975, it's alleged you committed that offense on or about July 5th of 2025 in Jefferson County by discharging a firearm at or in the direction of a habitation, a home. Namely, discharging during evening hours in the front yard of a neighborhood surrounded by several homes. And that's a third-degree felony if convicted, which carries with it up to 10 years in prison. But the hits did not stop. Then this is 26 CR 978 alleges that about 9 months later, March 15th of this year, in Jefferson County, Texas, you are charged with discharging a firearm at or in the direction of some individuals. That's another third-degree felony, which carries with it up to 10 years in prison. So you're looking at a total of up to 20 years in prison. Do you understand?
Yes, sir.
But what are his bonds now?
His bond in 0978 is set at 500,000, and on 0975 is set at 100,000.
All right, the court has a copy of a public safety report of the defendant. And I'm looking at prior criminal history. They're reflecting, let's see, in history. Showing an arrest date on 3/16/26 for deadly conduct, and it was filed as a misdemeanor Class A. I just don't think that went anywhere. Because I'm looking at the indictment in 26 CR 978, which alleges on or about March 15th.
Yes, sir.
That is alleged he committed deadly conduct, and that's the indictment in 978, which I guess is what guess the misdemeanor must not have been filed, and then the felony was later solved. Then there is nothing about the July 5th deadly conduct here in the July 5th of 25 in the public safety report, strangely enough. But then we do see an evading arrest and detention, a misdemeanor, where he was put on probation for 6 months and that probation expired. What this shows in the public safety report. I don't see a prior felony conviction.
No, he doesn't have any prior felonies.
But what? Oh, I think I understand. All right. The first event in time, July 5th, 2025, from 26 CR 975. By the way, both of these indictments were handed up by the grand jury on May 20th of this year. It's a couple months ago. And in this first indictment on or about July 5th of 2025, the law enforcement receives information that the defendant and two others were firing weapons in and around neighborhood homes, and not only do they hear about that from other witnesses, but they have a video showing him doing it. Thereafter, on March 15th of 2026, the defendant is at Rogers Park and multiple shots were fired in Rogers Park, which was life-threatening to homes and others. And apparently, this defendant was among others who were discharging the firearms at that location. So the defendant is charged with deadly conduct, third degree felonies. Go ahead, Mr. Lewis.
Judge, this time I call Terrence Perkins.
Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Go ahead, Martha.
Mr. Perkins, will you state your full name for the record? Terrence Perkins.
Yeah, I can't hear you.
Perkins.
She has to take everything down. Thank you.
Yes, she got to take it down. Okay. Now, for us, my client, the defendant, Dante Perkins, what is your relationship to him, his father? And where do you currently reside?
12730 Mercer Street, Columbia, Texas.
Now, if the bond is able to be reduced where y'all can bond him out, is that where he would be residing?
Yes, sir.
Okay. Who else lives at that home?
Well, his mother, his brother, his sister.
Okay. Typically, what is your work schedule like? Just to kind of put that out.
My work schedule, I work night shifts from 1:30 p.m. to 3 a.m.
Okay. Now, even with that, is there normally someone there to supervise or be around the home to know what's going on?
Yes, and mom.
Okay. Now, when it comes to Dante, at the time that since he's been in custody, prior to that, was he employed or working anywhere?
No, sir.
So he had no funds saved up or money saved up for that time. Does he have any type of property or anything that can be used to put on? Anything for collateral?
No, sir.
Okay. So who would be his co-signer or responsible for the bond?
I would be a co-signer and responsible for payments.
Okay. Now, as far as you do you have any property or anything that can be used to secure the bond?
Only stay here.
Anything for us that could be sold or anything to securing the additional funds?
No, sir.
So any funds that will be used for the bond will come from you or the family?
Yes, sir.
Okay. At this time, have you been trying to secure the bond at the amount that it said?
Yes, it's called a couple of ones said was 15,000 and other didn't even want to touch it. So that's just I can't make that bond at this current moment. Not at that price.
Okay. And you said majority of the bonding companies said they wouldn't even touch it at the amount it said. Okay. What do you think reasonably you and the family could do with a bond amount?
Both to like 50.
Both at 50,000? Yeah. So it would be a current financial obligation of $100,000.
Yeah, that would be a time.
Okay. And that's something that you believe you and the family will be able to do?
Yes, sir.
Okay. I'll pass the other sheet.
Mr. Perkins, did you assist in bonding Dante Perkins out in 2024 when he was charged with the evading?
Yes, ma'am.
Okay. And were you aware that he pled to that evading?
No.
Are you aware that while he was
That's a fact.
Yes, sir.
You're not aware that are you saying you're not aware that your son pleaded guilty to a crime?
Oh, okay. I didn't understand what she was saying. Said pled. Yes, he didn't receive probation for that. Yeah.
Are you aware that while he was out on bond on the evading before he pled, that first July 5th, 2025 deadly conduct charge where he was firing a weapon in the neighborhood of Euclid Street, were you aware of that offense?
I wasn't aware.
Were you aware of what occurred in Rogers Park on March 15th of 2026?
No.
So, and are you aware that both of those events occurred in the middle of the day?
I am aware of that. Seen, heard about it, seen.
So when you talk about somebody normally there to supervise Dante, who was supposed to be supervising him while he's out firing weapons in July of 2025 and March of 2026?
So at that moment, he wasn't staying with us, but if he was released on bond, he would be on an ankle monitor. So that would restrict his movement and confine him to the home.
Who was he staying with?
He kind of back and forth from my house to his friend's house.
Did Dante graduate high school?
Yes, he did.
What year did he graduate high school?
Dante graduated 24. Yeah.
How old is he?
Dante 19.
So how can you or his mom ensure that the community is safe from Dante out in the middle of the day firing weapons into our community?
So, like I said, he'll be on an ankle monitor, and if Dante does anything outside the guidelines of his bond, I'll get off the bond. So,
Did you know that Dante possessed possessed guns in the first place?
no, I didn't know that he had any guns.
So you feel that an ankle monitor is going to keep Dante from firing guns into our community more than these 2 times he's already done accused of it?
Yes, situation, I'm pretty sure Dante's heard about this lesson. With the ankle monitor, he can't no problem with that. So, yes, I do think it would be helpful to.
But the ankle monitor tells the monitoring company where he is. It doesn't stop him from moving around, correct?
It doesn't. They don't have one to where he can only be at the house and only go like for a job search or something like that.
So are you aware that somebody can tell him that those are the parameters, but Dante can still go and come where he chooses to?
No.
Are you aware of that?
Well, I'm just learning about that.
No further questions, Judge?
Just a quick redirect. Mr. Perkins, as far as the how long would Dante is in custody?
From Washington now, like 5 months or something like that.
Okay. Is this the longest confinement he's had?
Yes.
At his age?
Yes, it is.
At this, so do you believe that this has definitely been an eye-opening experience for him going through this?
Definitely, I do.
Okay. And do you think that an ankle monitor or additional bond conditions could be a good deterrent for him to help him follow his way?
Yes, I think that would be a great deterrent.
Okay. And just to reiterate, as you as the co-signer on the bond, you have no problem if he doesn't comply getting off the bond, or
no problem at all.
Understand that the court would have to do what they have to do
exactly
at that moment.
Yes, sir.
Okay. Pass the witness.
You don't think the probation back in 2024 should have been a deterrent?
Yeah, I feel like it should have been,
That didn't work though, did it?
Yeah, it was just it should have been a deterrent, but at the same time, I think he's been sitting in there for 5 months now, and he really sees the seriousness of his actions at this current moment. That was just the guys just think that it was, but him sitting in there 5 months, I think he really sees the severity of it.
No further questions, Judge.
Okay. So are you saying he didn't see the severity of it as he was shooting up a neighborhood and then shoot? I'm speaking. You get a chance to speak. We can't speak over each other. The court is going to ask you some questions so I can clarify this. You don't think he was smart enough to figure out that shooting up a neighborhood was wrong? Thereafter, going to a park, Rogers Park, and shooting up the park.
Yes.
You don't think he couldn't figure that was wrong the first time he did it? Based upon the fact that he had been in trouble in a past experience and had been disciplined for it? Does he have any learning problems? So he should have known.
Yes.
He should have been aware. I understand. He was 17 and 18 during each of these situations. 17 on or about July 5th of 2025, when the neighborhood was shot up. And then 18 when he is at Rogers Park. And these were incidents that occurred, looks like about a year. About one occurred on or about July 5th of 2025. That looks like 6/14 in the evening. And then the Rogers Park incident occurs. On Sunday, March 15th. Did you look at that? At the exact same time, 6:14, according to prompt cause.
I did not recognize.
What are the odds of that? It sounds like there's a time that some people get together, if this is true. What are the odds that at the exact same time, 9 months apart, this town is being shot up? Well, we're, by grace of the good Lord, I think, we didn't have a bunch of deaths here. What bothers this court is the defendant had been held accountable earlier for an offense and was placed on a form of supervision. And on this evading arrest back in 24, which was a little less than a year before he starts firing weapons in public. And he was placed on probation for 6 months, and that expired. It doesn't say the date it expired, but I presume it expired before the July 5th, 2025 incident. They were on 6 months, but the arrest date was July of 24. And it doesn't show the date that he was placed on probation for 6 months. Do you
I
know
believe it was September 10th of 2025, Judge,
that he was placed on probation?
that he was placed on 6 months deferred probation.
So that would have ended in March of
2026.
5.
March of 2026.
Standby. When was he placed on probation?
September 10th of 2025. It should be on or
Oh,
about that day.
okay. It's not showing a date. It says arrest date was 7/26/24. It took him a year before he's placed on probation.
That's what I'm showing in the
The date again?
history. September 10th of 2025.
So he would have been placed on probation 2 months after the shooting of the neighborhood.
Yes, sir.
And so he was on. When did his probation expire on 9/10/25? Can we find that out? The 9/10/25 probation. Please. We got a great probation office. They can figure all these things out quickly. It says that community probation expired 6 months. And if he was placed on probation on 9/10/25, that would have been somewhere about March 10th.
9th, yes, sir. Up at midnight on the 9th.
Is that what you're showing on the records?
Oh, she's done, I'm waiting on her to respond, but if this case expired, it would have expired at midnight on the 14th or 9th. Judge, I show that an order terminating deferred probation was filed in the misdemeanor case on March the 16th of 2026. That's when it was filed into the case. Let me see when the judge signed it.
Say that again. Say that again, please, so everybody can hear.
Yes, sir. So the dismissal of the misdemeanor deferred probation was filed in the misdemeanor case on March the 16th of 2026. His case expired on March the 9th. The only thing I can think of is the officer didn't send the paperwork through.
All right, so it expired on March 9th, 26.
And Judge, I'll print a copy of that
Thank you.
determination.
6 days later, he's at the park shooting. The following day, his case was formally dismissed. I mean, the probation was still warm, the end of it, and it expired, but the order was not signed dismissing it until the day after he's shooting up Rogers Park. So that probation must not have been impactful. Didn't take you but a couple of days to continue your violent behavior. March 16th by the County Court of Law Judge. Sorry, Marvin, that doesn't help.
Understood.
That's terrible. Your relief you're requesting is flatly denied. He has shown from his history and his lack of appreciation of the seriousness of being held accountable in the first place, that violent behavior is something that he can't prevent himself from committing. So reducing his bond would only put us all in jeopardy and harm's way based upon his lack of appreciation of remediation of his conduct, in light of the fact that just days after he's finished his probation, he's doing a second set of violent shootings in Rogers Park. That this court finds reprehensible, and you will be held accountable in each of these two cases. The relief you're asking is denied based upon those reasons. I find him to be a threat to the well-being of the community based upon showing these actions and these time periods. That is all.
Thank you, Judge.
Alrighty, friends, TCF Live on a Super Friday in our last half hour. Now, a little bit of business to take care of before we move on. First, Michael, thank you for gifting a membership. Barbara, thank you for gifting 5. I appreciate you both. Also, held up here to the camera, as well as it will focus in, this is the latest postcard I got from our friend Rahul, who says, "Hi, Dan. Thought I'd drop you a random thank you. I'll probably be on vacation when you receive this. I'm grateful for the people that foster and maintain my positivity. Thank you." So thank you, my friend. I appreciate that very, very much. Okie dokie. I promised you guys an announcement in hour 4, so let's make that announcement. Starting Monday, TCF is going to add another live program to the docket. Specifically, second session be Monday through Thursday, 2:30 p.m. Eastern, 11:30 a.m. Pacific, so around a midday show. It will be a tight 60 to 90 minutes. It will not be morning show part 2. It will be produced differently. It will look a little bit different. It will clearly still be a TCF show. However, it will not exactly be what you get here. The idea here is more cases, more context, no wasted time. So we're going to move from case to case to case. There will be cases you have not seen here on this channel before, and I think it will be a lot of fun. So do join me for second session starting on Monday, 2:30 p.m. Eastern, 11:30 a.m. Pacific. I'm really looking forward to this one because it'll be something new for the channel, something just a little bit different. Okie dokie, not quite time yet for Dungeon Court. Let's go to Michigan. Judge Meineke for one more.
Yeah, it's going in. He's in right now. Is Mr. ADR case Miss Clark's or it's Mr. Tracy, right? It's Tracy. Shit. All right, Ms. Nuccio, I have a probation violation, the request for resentencing on a OWI case, person in sobriety court. Obviously, would love to have you here on this. But just want to, I don't know if you were made aware or not. So
yes, the probation officer caught me up this morning. Thank you, Your Honor.
Very good. Ms. Dial, do you need to speak with your client?
No, Your Honor, we're ready to proceed.
All right. On case number 26-01171, Damon Emerson.
Good morning, Your Honor. Danielle Nuccio on behalf of the people.
Good morning, Your Honor. Deja Dahl on behalf of Mr. Emerson, who is present via Zoom. We do consent to Zoom. However, he is currently muted, Your Honor.
All right, Mr. Emerson, let's get you unmuted.
Good morning, Your Honor.
Can you state your name for the record, please?
Damon Emerson.
All right, today's date and time set for a probable cause conference. Ms. Dodd?
Judge, that's accurate. I did submit a deviation request to Mr. Spencer. I haven't heard back yet. I'm asking to set the exam date.
Your Honor, may I speak to that to update Ms. Dial?
Yes.
Any deviations requests made to Mr. Spencer need to be resubmitted. He is no longer with the prosecutor's office. And it's unlikely.
That's all right.
I'm sorry?
No, but there was a background noise from Mr. Emerson. That's all that there was a background noise. Please continue.
Thank you. Ms. Dial, it's unlikely that this would be reduced if you want to just go forward to exam.
If I would like to resubmit it, would it go to you or someone else?
If you send it to me, I can get it in the right place so that then it doesn't fall through the cracks.
Thank you. But understood. Can we set the exam date, Your Honor?
We can. All right. Can you ask that? Bear with me just 1 second, Councilman. I can do next week at 10:30, Ms. Dial. I know your client's in custody, so I could try to move this quick.
That works for me, Your Honor. Thank you. Are we able to address bond?
Well, let me finish writing the date in the file, Ms. Dial, and then we can get right into it, okay?
Thank you.
All right, we'll move this, we'll set this for exam in 1 week, August 7th at 10:30 a.m. in person. All right, go ahead, Esteban.
Judge, bond is currently set at $50,000 cash or surety. I believe it's a little high based on the charges. I understand that he was out on bond at the time for 2 CSCs that were pending in Wayne County. However, he has no other prior criminal history. He was working 2 part-time jobs prior to his incarceration. He was working at the Magna plant as well as Panda Express. He has some college education. He's single with no children. He would be living with his grandparents if he were to be released. I have been in contact with his grandfather. We're asking the court to consider a significant reduction or bond or adding a 10% provision. Thank you, Your Honor.
Thank you, Ms. Nuccio.
Your Honor, the people would object to any change in bond pending the preliminary exam. Given the charges here are assaultive and he has a criminal history of assaultive charges, the people believe the bond is more than reasonable and there was no abuse of discretion.
I don't see any reason to move from this with a new assaultive charge coming well on bond for obviously a very serious assaultive charge. I'd rather hear the facts of the case and examination before we get to any further discussions related to bond. I can't find that the magistrate at this point in time abused their discretion, and I will take this matter up again when we have our examination next week.
Understood. Thank you, Your Honor.
All right, thank you. See you in a week.
Alrighty, my friends, it is that time on a Friday where we engage in TCF Live's guilty pleasure. We go to the courtroom with the blood red carpeting, the sandstone walls that leak just a little bit of blood from time to time, the Soviet Cold War era lighting hanging from the ceiling over the aged desks, the printer that never stops running, the one microphone covering the entire courtroom that's so overly modulated you can hear the bugs crawling along the carpet, the moans and screams of terror of those in the background, the cries of the undead. There's a lot going on in this courtroom. With a guest judge today as Judge Clapper or Capper or whatever the hell his name is, has unfortunately for today been called back to the underworld as a guest judge himself on the Superior Court of Hades, but hopefully he'll be back next week. But ladies and gentlemen, they say that Appalachian justice is best served in a cold, dank basement. Therefore, I give you Dungeon Court.
Chase Holdren. All right, this is state law. Chase Holdren, 0.5772. All right, that's a good report, Mr. Holdren. set you back September 18th for review at 9 a.m. Ms. Jackson, State of Ohio versus Randy Jackson, PRC 25-2359 A and B. And Ms. Jackson, you are the star of the day. You have done 52 hours of community service since your last hearing, and you're just down, it looks like, to $449 left. So you're making good progress on getting this resolved. Because you've done so well, I'm not going to set you back so far. So I'm going to set you back October 30th for review at 9 a.m. And with any good fortune, if you keep up your pace, that will be paid off before you need to appear, and that will be vacated.
Yes, sir. Thank you.
Thank you, Ms. Jackson. Bertha Remy. Okay, it's the State of Ohio versus Bertha Remy, CRB 26-233 A&B. And I was given a report, Ms. Remy, and it looks like you're continuing to test positive for THC, and not only are you testing positive, but your levels continue to go up.
Your Honor, Ms. Remy's not here.
Oh, so she just didn't hear.
She needs to go in residential. She is not open to the idea of change. I know she's got some things going on, but we've had screens of positive oxycodone, hydrocodone. I didn't know I was supposed to be there. Oh, I don't have a car. She just needs to go in.
Well, there's an easy way to accomplish that. She has not appeared here today. So I'm going to issue a bench warrant for failure to appear. If you hear from her and she comes in, I will take up the issue at that point, but I would anticipate that is not a good report, and we will handle that issue when we have a report.
Thank you, Your Honor.
All right, thank you. Angela Spurlock?
Yes, sir.
All right, this is State of Ohio versus Angela Spurlock, CRB 18-1327, CRB 18-1297, and CRB 18-558. All right, you're making some progress, Ms. Spurlock.
Well, I'll have my community service done by next court date, for sure.
So I'm going to set you back for review on September 25th.
9 a.m., correct?
9 a.m., correct.
Thank you, Your Honor.
Thank you. Joshua Turner, the State of Ohio versus Joshua Turner, PRC 25-625 A&B.
Your Honor, Mr. Turner's done well. He's graduating from the residential program, and he's secured a very good job. He's reincorporating with his family. We're going to work with him on an outpatient basis just due to history and the environmental change.
Your Honor, if I may, he was ordered to do some community service on his last hearing, and he has turned in 21 hours this morning.
Okay. Well, that's by all accounts, that's excellent reporting, Mr. Turner. I'm happy that you're graduating. I'm happy that you've got a good job. You do have a substantial amount of community service left and a pretty high amount of times left, but getting working should be able to help with both of those. So you've done so well, I'm going to give you a little bit more time before we come back before the court. I'm going to set you back on October the 30th. That'll be a review at 9 a.m.
You mean down?
Yeah.
Thank you, Your Honor.
Thank you.
Thank you.
We're ready for arraignment, Your Honor.
All right, the next group of cases we're going to call are some arraignments that are ready. If you have an arraignment, I need you in the courtroom. All right, when you hear your name called, come down to the table on my left, your right, and we will go through your charge or charges with you. If it is a misdemeanor offense, you can enter one of three pleas: guilty, not guilty, or no contest. If you enter a guilty plea, you're making a complete admission that you committed the offense charged. If you enter a not guilty plea, you are denying that you committed the offense charged. And if you enter a no contest plea, you're not admitting that you committed the offense charged, but you're not contesting the facts surrounding the offense. And then if I think the state would otherwise have enough evidence, I can enter a guilty finding. You have the following rights before the court. You have the right to remain silent. Everything we're doing in here today is being recorded. So if you start telling me about your case, you may say something that you shouldn't say. And Mr. Keel, who is walking in the courtroom in the state of Ohio, can get a copy of that and potentially use it against you later at a trial. You have the right to have an attorney. If you do not have the money to employ an attorney, I can appoint one to you at no cost if you meet the criteria for that. You have the right to have a reasonable bond set in the matter. You have the right to force the state of Ohio to prove each and every element of the offense is charged beyond a reasonable doubt. We'll go ahead and call the first arraignment.
State of Ohio versus Cameron Lambert, CRP 26417, A, and C.
All right, this is State of Ohio versus Cameron Lambert, CRP 26417, A, and C. Sir, you're Mr. Lambert?
Yes, sir.
All right. On the A case, Mr. Lambert, it's alleged that on or about June 22nd, 2026, you did with purpose to deprive Lowe's, owner of property or services, knowingly obtain or exert control over said property or services, to wit, miscellaneous merchandise, without the consent of the owner or person authorized to give consent. That's an alleged violation of Ohio Revised Code Section 2913.0281. That is theft. That's a misdemeanor of the first degree. Misdemeanors of the first degree carry a maximum penalty of up to 180 days in jail and up to a $1,000 fine. On the B case, it's alleged on or about June 30th, 2026, you did with purpose to deprive Lowe's, the owner of property or services, knowingly obtain or exert control over said property or services, to wit, miscellaneous merchandise, without the consent of the owner or person authorized to give consent. Also an alleged violation of Ohio Revised Code Section 2913.0281, theft. That's a misdemeanor of the first degree. Maximum penalty on that's up to 180 days in jail and a $1,000 fine. On the C case, it's alleged on or about June 21st, 2026, you did with purpose to deprive Lowe's, the owner of property or services, knowingly obtain or exert control over said property or services, to wit, miscellaneous merchandise, without the consent of the owner or person authorized to give consent. Also a violation of Section 2913.0281, theft, misdemeanor of the first degree. Maximum penalty is up to 180 days in jail and $1,000 fine. Do you understand the charges that I just read to you?
I do.
And you understand your rights before the court?
I do.
How do you wish to plead?
Not guilty.
Okay, I'll accept your not guilty plea. Do you have the money to hire an attorney?
I do not.
All right. Are you working presently?
I am.
All right. Are you paid hourly?
I am.
All right. How many hours a week do you get?
It varies. I just started the job. Only work 2 to 3 days a week right now.
Okay. How many hours would you say? So about 25 hours a week?
Probably 20 or so, yeah.
Okay. How much you paid per hour?
$15.50.
All right. You're going to qualify for appointed counsel. I'll appoint Attorney Roger Smith to represent you. Mr. Hill, do you want to be heard on bond?
Your Honor, we're not opposed to move our bond.
All right, and I'm gonna have to order Mr. Lambert's gonna have to get fingerprinted at the Lawrence County Jail, so he's gonna be ordered to do that.
I received a summons in the mail. And don't leave, I'll bring a copy of this to you.
Mr. Smith, how soon do you want to come back?
What's the date you're setting, Judge? I've got August availability.
Looks like the August 21st and or 24th start the better days. Prior to that, they're pretty booked up.
Okay, the 21st is better for me. That's a Friday.
Yep.
Is that a good day for you, August 21st? Yeah, my client's going to double check his calendar.
Yeah, August 21st.
August 20th, it's a Friday. It's 3 weeks out from today.
That should be fine.
All right, I'm going to set it back for August 21st for pre-trial at 10 a.m.
Your Honor.
It's going to be a $2,500 award.
Tell me just a point. I got it here earlier. You set an appointment with them before the 21st and bring that with you.
Don't give this to me.
Not there yet, because if we're going to talk about maybe the stuff you need, then you're free to go.
Okay.
State of Ohio recalls Bertha Remy, case number CRB 26233, A and B.
All right, this is the State of Ohio versus Bertha Remy, CRB 26233, A and B. This matter was set for review hearing, and Mr. Remy wasn't here, even though she was here at 9 a.m. There was a warrant issued, but I indicated that if she appeared, I would call that warrant, so I'll go ahead and note for the record that the warrant's recalled. Ms. Remy, I'm going to recap kind of what was said on the record here. I received a report here, and it is not a good report. And I will read to you exactly what was listed in the report here. Bertha continues to test positive for cannabis, indicating ongoing challenges with abstinences and the need to continue support and strengthening recovery-oriented behaviors. Though there is progress with her THC levels, they continue to raise, and there have been growing concerns over opiate use. And the treatment provider believes it is in your best interest for you to be placed inpatient. Taylor, anything that you wish to add to that? I know that there were some things that you had indicated for the record earlier.
After meeting with her clinician, there's been some resistance about issues that are prevalent. And I mean, you can look confused if you want, but your THC levels are going from like 600 to 1,000. And then there's a hydrocodone and oxycodone positive in there a couple weeks back. It's just, we feel it's in her best interest to go into residential.
All right, Ms. Remy, I'll give you an opportunity to speak before I...
Yeah, Mr. Capper, the first couple weeks was messed up. I had a tooth break off. That's why the pain medicine was there. I've not had any since then. The THC level, I'm waiting on a neurologist, which I have stopped. I mean, I don't know why the levels have even, like, I don't drive, so I mean, that's, I'm trying. I have done, like, we've moved to Pike County, and I have put everything, there's no one that'll try harder. Like, I have really cleaned myself up. And, yeah, the THC has been a problem because it's been 20 years for medical use. I had epilepsy. So, but there, I mean, there's no one that's trying harder.
And it's not that we don't believe that she's trying, it's that she doesn't have the skills that are necessary to maintain it.
But I have a different support system, and we're working on changing everything. I was kicked out of my home I lived in for 20 years, so there was depression issues on top of that. You know, my dad told me he didn't want me no more, so, you know, therefore there was that. But I've changed my life around. It's been a whole life change, and even in outpatient, they're helping me, like,
Well, I'll tell you, Ms. Rennie, here's how I approach these cases. I don't practice medicine. I don't practice psychology, any of those things. Hang on, let me speak. I have to rely on people that do those things in order to know what you need. I don't know you. I don't know your personal background. I know what little history that you've given me and what's in the report, but the reports going back have all said kind of the same things. And I have to rely on the providers to tell me what it is you need. And so they're telling me that you need inpatient treatment.
I have a doctor's appointment on the 27th with Erica Schuster. She tried to get me to come when my mom passed, and I didn't. I should have listened. I have a long time.
Seems to be a lot of that going on.
Right, I have a long-term fear of doctors.
So I'm going to go ahead and stop you at this point. I'm sure that Bethesda will get you to that doctor's appointment if that is an appointment, but at this point, you're either going to have to go inpatient treatment or we're going to have to go another route that does not include treatment. And that other route likely lands you in Lawrence County Jail. So those are your two options. Do you prefer the treatment or do you prefer jail?
Sorry. There's nothing on my screen. You're gonna get passes and stuff like that. You've got trauma, you've got a ton of things going on that need to be addressed in order for you to have that life.
I've just been given the first chance in my life to buy my own property. And that's why Judge Capper was working with me a little bit.
And Judge Capper left a note that basically is that we better have a compliant report today. And
I thought I was compliant. They said my levels was going down. I talked to the mental health counselor yesterday, and she said my levels were going down.
They spike and then they went back down. So that's what that means. So there's use and then it comes back down. So I'm not here to justify what you're doing.
Right.
The lab is the lab.
Right, but I don't understand that stuff.
I've already told you, I don't need to hear anything else. I just need to hear whether you're willing to do the treatment or whether we need to go another route. Because if you don't want to do it, then I don't have much by way of option. I mean, you got to do what's been ordered, and you were ordered as part of this. As part of your probation to do what's required by your treatment provider. And your treatment provider is saying you need inpatient treatment because you're not compliant.
I'm sorry for the pause. I'm shocked because like I said, I don't apologize for my pause because this is not an easy decision.
It is, you get a better life.
My life was turned around when I was taken out of the position that I was in that caused the issue of me being
Well, here's what we're going to do right now. I'm going to go ahead and remain her into custody at this point. She can think about it in the back. We'll have you out later in the docket.
Thank you, Your Honor.
All right, Lindsay, thank you for $10 for TCF overtime. Just because of that, let's put in another 10 minutes or so.
Case number CRB 23754, CRB 2145, A, B, and C, CRB 19738.
All right, this is State of Ohio versus David Woodward Jr., Series 23754, Series 2145, A, B, and C, Series 19738. And it looks like Mr. Whittier failed to appear for review. Some time ago. Mr. Whittier, do you admit or deny that you failed to appear for review?
Admit.
Okay. And do you have a good reason as to why?
No, I don't.
All right. How long have you been in treatment with RRS?
July the 17th.
Okay. And did he come in on his own?
Yes, sir.
Well, that's a good start, Mr. Woodyard. So here's what I'll do. I will recall any outstanding warrants out of this court, mainly because you checked yourself into treatment. I am going to set you back for another review hearing, and I'm going to order that you remain in that treatment as part of your sanction for not appearing. And I'm going to set you back for another review on August 31st. That'll be a review at 9 a.m. And you're ordered to continue your treatment with RRS.
Thank you, Your Honor.
Thank you.
State of Ohio versus Adam Bates, case number CRB 26466.
All right, this is State of Ohio versus Adam Bates, CRB 26466.
Yes, sir.
All right, Mr. Bates is alleged on or about July 28th, 2026, you did purpose to deprive Walmart, the owner of property or services, knowingly obtain or exert control over said property or services, to wit miscellaneous merchandise without the consent of the owner or person authorized to give consent. That's an alleged violation of Ohio Revised Code Section 2913-0281. Theft, that's a misdemeanor in the first degree. Misdemeanors in the first degree carry a maximum penalty of up to 180 days in jail and up to a $1,000 fine. How do you wish to plead?
Not guilty.
All right, I'll accept your not guilty plea. Do you have money to hire an attorney?
No, sir.
Are you working?
No, sir.
All right, so you have no income?
No.
All right, I'll appoint Attorney Sean Stratton to represent you. I'm going to continue the current bond. He's already posted a bond with Mr. Sowers. Mr. Stratton, when would you like to come back?
It's up to the court.
Fridays are best for you? Is that correct?
Any day, but the 17th and 24th of this month are not good.
Okay, so we'll do the 21st.
21st, okay.
That'll be a pre-trial at 10 a.m. And he'll need to go to the jail to get, were you booked into the jail?
Yeah.
Okay.
So he should already have fingerprints.
Yes. Okay. All right, I'll see you back, Mr. Bates, August 21st at 10 a.m.
All right, thank you.
State of Ohio versus Shannon Brunson, case number CRB 26468. Shannon Brunson.
All right, this is State of Ohio versus Shannon Brunson, CRB 26468. Ms. Brunson. It's alleged that on or about July 29th, 2026, you did purpose to deprive Lowe's, the owner of property or services, knowingly obtain or exert control over said property or services to give miscellaneous merchandise without the consent of the owner or person authorized to give consent. That's an alleged violation of Ohio Revised Code Section 2913.0281. Theft, that's a misdemeanor in the first degree. Carries a maximum penalty of up to 180 days in jail and up to a $500 fine. How do you wish to plead?
Guilty.
You want to enter a guilty plea? So you want to make a complete admission that you committed the offense charged? No, I see
Yes.
none, but okay. All right, I'll accept your guilty plea and enter a guilty finding. Prior to us doing sentencing, I'd like to have her your own screen. So we'll have you back out here shortly to do something.
Okay, well, okay.
State of Ohio versus Emily Lockwood, case number CRB 26467.
Are you Emily Lockwood? Yes. All right, this is State of Ohio versus Emily Lockwood, CRB 26467. Ms. Lockwood, it's alleged that on or about July 29th, 2026, you did purpose to deprive Walmart, owner of property or services, knowingly obtain or exert control over said property or services to wit miscellaneous merchandise without the consent of the owner or person authorized to give consent. That's an alleged violation of Ohio Revised Code Section 291302A1. Theft, that's a misdemeanor of the first degree. Maximum penalty on that is up to a $1,000 fine and up to 180 days in jail. How do you wish to plead?
Not guilty, Your Honor.
Except you're not guilty, please. Do you have money to hire an attorney? Are you working?
Not right now.
All right. So what I'll do is I'll appoint attorney Roger Smith to represent you. Looks like there was a medical OR bond, so I'm going to go ahead and issue a $2,500 OR bond in lieu of the medical OR bond. And she's already been fingerprinted. And Mr. Smith, I already know you're here August 21st. So
That's a good day, Judge.
I'm going to set you back August 21st at 10 a.m. for a pre-trial, Ms. Lockwood.
What's the date, Your Honor?
August 21st. Apparently, there was something in the water on July 29th, because every charge we've had has been death charge from that day.
Okie dokie, friends, this seems like a good place to call it for the week. Thank you all so much for all of your kindness and support and everything else that you've shown me throughout the week and shown each other. Very much appreciate it. We will be back, obviously, Monday, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. Yes, the pre-show comes back on Monday. Plus, a reminder, new show starting Monday, second session, 2:30 p.m. Eastern, 11:30 a.m. Pacific. Got to get used to saying that. Our new live show, which will start Monday as well. So everybody go have a great weekend. But before you do that, let me leave you with this bit of wisdom from Epictetus. How long are you going to wait before you demand the best for yourself? It's a good question. Ponder that one this weekend. Y'all have a good weekend, and we'll see you Monday. Take care. God bless.